all phones at this time, please. If you have a cell phone, please silence it.
Both of mine?
Okay. You better, did you hear that, Sheriff?
Okay, everyone, we have the red light. That means it's ready, we're ready to go. And good morning and welcome everyone to the May 15th Rankin County Board of Supervisors meeting. We'll call it to order at this time, and we'll ask Mr. Craig Slay if he would do the invocation.
Let's pray. Father, we're so grateful for the opportunity again to come before you today to conduct the business of the county. Father, it's a privilege to serve, and we thank you for that privilege. We don't take it for granted. I thank you, Father, for this country where we can come together, assemble together in freedom to conduct the business of the county. Father, you give us that privilege. It's a blessing, and we thank you for it. Lord, I thank you for the men and women who protect us. They serve us and protect us. I thank you for their sacrifices. I pray, Father, for their protection and their safety. And Lord, I pray that for those men and women who are fighting for the cause of freedom all across the world, Father, would you bring them home safely to us and protect their families while they're away. In Christ's name.
Amen. Amen. I'd like to say just one quick thing to add to that. I realized this morning that this May is Police Law Enforcement Month, and I think we need to remember all our law enforcement. We have a couple that were down toward the I believe it's Hattiesburg area that were young men that were shot and killed. But you know, we wouldn't be what we are here in Rankin County and many parts of the state if it was not for our law enforcement, our sheriff's department, and our cities that protect us and make it. We don't realize how good we do have it, but it all, you know, when you see a law enforcement or a sheriff, any type of law enforcement, thank them and wave to them. You know, you don't always want them pulling you over, but they do the right thing, and they're why we feel safe to have our children and our families go to Walmart or go somewhere, and it's not like that all over, but Rankin County is good. So anyway, remember that. Let's remember them. But anyway, moving on, public comments and recognition. We're honored today to have Pelahatchie High School girls basketball team, Class 1A state champions with us today. And this time, Mr. Slay is going to come up and do a resolution. We are really proud of you all for what you've accomplished and what all you show. You make Rankin County proud and all of us proud, and I know it took a lot of hard work and a lot of great leadership to get you all where you are. So congratulations.
Mr. President, it's an honor and a privilege to welcome the Pelahatchie High School girls basketball team, the Class 1A state champions for 2014-2015. We have a resolution to read. Girls, as I mentioned, when you hear your name called, I want you to come forward and stand right up here, okay? Here we go. This is a resolution commending and congratulating the Pelahatchie High School girls basketball team upon winning the 2014-15 Mississippi High School Athletic Association Class 1A state championship. Whereas on March the 13th of 2015 at the state tournament held at the Mississippi Coliseum, the Pelahatchie High School girls basketball team won the 2014-15 Mississippi High School Athletic Association Class 1A state championship by defeating Ashland High School 54-48. And whereas the Lady Chiefs finished their championship season with a final record of 27 wins and 5 losses. And whereas the Lady Chiefs are led by head coach Pearline Fairley, assistant coach Camelia Green, and assistant coach Duncan Tucker. Come forward, coaches. And whereas the members of the Pelahatchie High School girls basketball team for 2014-15 are seniors Candace King and Brittany Thompson, juniors Tequila Beeman, Tequila Beeman, Alexis Hobson, April Tyser, Talika Mazik. Our sophomores are Aubrey Beeman, Haley Jones, Janae Colliard, Courtney McGee, and Jemiah Stokes. And our freshmen are Kenosha Holyfield and Morgan Hobson. We have our managers, Elisa Walker, Did I get that wrong, Gary? Alyssa? Elissa. Thank you. See, you got even more attention. Jalea Boyd, got that right, and Brianna Ferguson. And whereas it is with great pride on behalf of all of the citizens of Rankin County that we recognize the accomplishment of this group of student athletes who have brought honor to their school, their families, and to Rankin County. And therefore it's resolved by the Board of Supervisors for Rankin County that they are commended and congratulated. The Peleachi High School girls basketball team for winning the Mississippi High School Athletic Association Class 1A state championship. And we recognize their excellent 2014-15 season, and we extend to the team, the coaches, administrators, and their parents our best wishes for their future success. That's resolved today, the 15th day of May, 2015. Coach, we have a resolution that's signed by the Board of Supervisors, and we are excited to commend you, you ladies, on your accomplishments. We're proud of you. We're proud for Rankin County, and we're grateful that you're here today to let us celebrate your victories. Join me.
Congratulations, girls.
Congratulations, coaches.
Slam on me.
Y'all have a great day. Thank you.
Okay, next we can just you can start getting ready as they ease out. We have Tim Nelson with Vector Control, report on Vector Control. You want to come forward, Brian? Good morning.
Good morning.
Good morning.
Board of Supervisors. I'm Tim Nelson, Business Development Specialist for Vector Disease Control International. Mosquito control. I'm operating mosquito control here in Rankin County. I have a report there for you folks, and I apologize, I've actually got it backwards in there. I'd like to just kind of briefly go through it and start in the back of the book.
That's the way I thumb pages anyway. Okay.
Okay, it shows here where the trap, where we run traps, of course, CDC light traps and gravid traps. The gravid traps, of course, are to catch our disease-type mosquitoes. The CDC traps are more for the nuisance, so we've set them out throughout the county. We're running 10 early in the week and 10 latter part of the week to get our counts. And anyway, we can go from there to flip back a little, I don't know, 8 or 10 pages there, and you start seeing a few where we have here earlier in April where we run 5, and it shows little triangles. Now, next meeting you'll have quite a few more sites on a map to show you where we have the 20 sites in addition with this. So, and from that point, we'll come back up through here to the larval surveillance. If you can get to it, you'll come to a map with some little red dots on it. It shows the larval surveillance, and if you find this is the one I'm talking about. You can find this.
Yeah.
Okay. Yep. That shows where we're doing larval control, where we're putting Aquabac 200G and granulars in the ditch, the water pools where we're finding larvae or that could be possible problems. So also, if you'll look, there's a dense area with red dots up around the southern end of the reservoir. We had a hatch off there, and the mosquito counts came up, and we'll get to that. You'll see that in a graph here shortly. We were immediately on top of that with larvicide and also some adulticiding, and got those knocked back. Okay. And if you keep flipping back toward the front, as you can see as you go, you'll see where on this literature it shows where we treated ditches, how much, and what type of larvicide we used. And there's quite, it'll say, you'll see where it says Aquaback mostly, okay? I mean, there's places, if you look, it shows, your first part, it showed the location, whether it was Castlewood Drive or Bradford Drive, et cetera, and then how many larvae, the amount of larvae, and then the product that we put out.
What is I guess an alerted number when you talk about number of caught? I mean, what?
Well, like the adult part of it, you have the NPDES, you go by a threshold, but for the most part, on the larvae, when you find larvae, then you have to larvicide, so that's an alert immediately that you got little larvae in the water, so they're going to hatch out eventually. So you keep up with them through their instars, first instar, second instar, third instar, and fourth instar, they're fixing to hatch out. So you got to put the product out, in the proper time to make sure that you do not let those become adults. So the more larvae that we take care of, the less problem we have with adults. Because the last thing in true mosquito control is the adulticiding. Now, on the other hand, it's going to become necessary to adulticide also. Okay, so, and you keep backing up here, and like I say, I apologize, I should have had this in a different order. We should have had what we're starting in the rear and the front, and it'll be that way from here on. Okay, and then you just keep looking, you can notice there's a number of ditches and areas that we've been treating with larvicide. Okay, if you keep going, you see this graph where I was talking about the counts went up. Okay. All right, so this graph, as we go through the year, it'll continue. You'll be able to tell as everything is through the year. This graph show you how things have, where we've had hatch-offs, and the mosquito population came up, etc. So, okay, and then if you come on back, you'll start seeing maps. It's little green areas that show where we had to spray. These areas where the counts come up. Okay.
Right.
So, and if you go through there, it'll give you the information. How much we sprayed, how many miles we traveled, etc. And of course, you can see the area we sprayed.
How do you pick your trap locations?
Random. You kind of look, map it out to start with, and look in the areas for problem areas, and then set those traps. Anything from the water pools to grown-up areas that where there may be a lot of people involved, activities, softball fields or something, or whatever it might be, fairgrounds, etc. But mainly, you want to set the traps, and like the gravid traps, those will be moved about and changed. And so some of the CDC traps, we'll have those located normal, but sometimes we have to move these traps to make sure we're staying on top of things, because you're going to be in one area, you have to move them ever so often.
I think that's what I was wondering. If you obviously got to rotate them around.
Absolutely, yeah. Especially the gravid traps, because the gravid traps we use to try to catch the mosquitoes, so we can have them sampled, tested to see if we have any type of disease problem.
Okay.
Let's see. Is there any other questions?
On these, will you be doing this periodically as far as giving us an update on this?
Yes, sir. I'd like to be able to give it monthly.
That's great.
Something Tim and I talked about is we're going to have this report for you at the work session.
Right.
So that you have time to take it home and look at it. And if you come up with any questions, then it'll be there
Good.
for the board meeting too.
Man,
we're working out bugs here,
right.
little bugs and stuff.
That's on fun. That's pretty good. Working out.
Yeah,
bugs.
I like that.
You ain't kidding.
I was actually talking to some folks yesterday, and I was talking to this fella, and he was like, glad that we were here and stuff, and I looked on his forehead, and he had a mosquito. I was like,
you just reach up, pop it.
We'll put a trap over his head, right?
Right, but these reports will, I promise you, will be even better as we go. They're getting better and better. The information, and we'll have it from month to month, where you'll be able to tell exactly what we've been doing.
Right.
And I think all of you folks ended up with a business card of mine.
Right.
So feel free to let me know about any constituent complaints and so on, and we'll be on top of it.
You sure?
I was gonna say too, I've only had about 2 calls, you know, people just checking on the spray and everything. I forward them on to his office and he replies back that
Good.
they've taken care of.
How many different types of mosquitoes are there?
Oh, 2,500 or so,
How many?
2,500. In
Wow.
this area, I'm gonna relay that back to my regional director, I believe would be how many?
60 in Mississippi, but probably 5 or 6 here in Rankin County that are
Yeah.
native reported.
And only
Yeah.
certain species carry certain diseases. So.
You know,
Right.
you'll have like Culex mosquitoes carry West Nile, Albopictus carries disease, Anopheles are a nuisance malaria mosquito, but we don't have a problem with malaria. You know, Serophora, there's a number of different species.
Wow.
Some are easier to kill than others, and the female mosquito is the only one that bites you.
Really? It makes sense.
Wasn't going there.
Glad to know that, Laura.
I live with a house full of women. Wasn't going there.
I think this is, this report is very good. I think, I really like the way that you're doing the traps, and obviously, we've not had a problem. We'd be here having phone calls, and what you refer to, relate to us, Brian says it, so right now, I know I'm happy with what's going on, so.
You know, as we go into the season now, understand we're going to have counts come up.
Right.
Yeah.
And we're going to have to address that immediately as they come up, and it's going to be a battle. It always will be. But there'll be more of this take place.
Yeah.
The
Right.
stuff you're seeing here now, this thing's going to end up getting thicker.
Well, the thing that I like here, I think, as what we're seeing in time, the public and constituents are going to see your activity, see the traps, and just that frame of mind goes a long way to know that you're on top of it, rather than just, I think, just seeing the truck go by.
Yes, sir.
That you're making an effort to identify things. Huh?
Absolutely, and
Yeah.
that's a lot of what the people never know
Mhm.
is there's more to it than just the truck.
Right.
Than the adult side.
Right.
Yeah.
So.
Staying ahead and
All right.
being proactive.
Right.
Appreciate that.
Exactly.
All right, good deal. Thank you.
Yes, sir.
Thank
Thanks
you
for
very
having me.
much.
Thank you,
Appreciate
Tim.
Okay, next, let's see, we have, I believe, Miss Jamie Patterson. You want to come forward? Mister, I'm sorry. We could have gone either way, my bad. If you would, kind of limit your comments about 3 minutes, if you don't mind.
Well, I'm here on behalf of the all residents on Barksdale Road. For the last 19 years, we have lived with them coming out and just kind of putting tar down and spreading rocks. And years ago, before the oil and gas people came in, right before they came in, they came and paved down Gin Road, part of Barksdale, and then turned and paved down Goshen Springs Lane. Well, they stopped at from one point down just about over half of Barksdale Road. And all the years they've done, they just came and patched and, squirted tar down and thrown rocks down. So we want to know, there's just as many houses down on our end that pay the taxes as it is on the end that got the nice paved road. So why can't they pave our road just like they did the remainder of the road? So that's kind of our concern. They're out there now resurfacing and kind of grind it up and packing it down. Completely understand why they have to go through the process, and we're willing to take the bad with the good. But when the end results is going to be coming out again, doing the same thing they've done for the last 19 years, is squirt tar down and throw rocks, we want to know, when are we going to get our road paved? Just like everybody else has had their road paved for many years.
I can't answer that exactly, but I will say that we do use that same application in many, many parts of the county. I know I could name numerous roads just in my district that have the same application. In fact, the road that I live on is done the exact same way, and we have quite a few there. So I only say that to let you know that's not just something we're just doing for your situation. Sure. Yeah, and in that it is a cost savings, and roads that aren't as heavily traveled such as mine, I mean, and maybe yours, as far as when I mean that, it's not through traffic. I call it in and out traffic.
Sure.
So that's another reason. It's just tax dollars and spreading it further to do more in other places. I understand your concern, but I just wanted to let you know that it's nothing isolated into your area.
Definitely. I completely understand. We understand that. We also understand that it would be fair if all of Gin Road and Barksdale Road and Goshen Spring Lanes was treated just like we were, but they're not.
Mm-hmm.
So how come we're paying the taxes that they're paying and they get the paved road but we don't?
Mm-hmm.
So why doesn't everybody out there on that road get the same treatment that we got, or vice versa? If their road is paved, how come ours is not? What determines that they stop right there when there's 15 houses down our road that doesn't have a paved road, and there's 15 houses down the other road that have the same amount of travel? How come they get a paved road and we don't?
Yeah, I really couldn't answer that. I guess it's just something we just have to look into and see. I don't know the circumstances at all, really.
Have you discussed this with our road manager?
I'm sorry?
Have you discussed this with our road manager?
Yes, sir. And the response that I get from him is our road is not ready. And I get that, and every time that they've come out and done what they're doing right now, I call and I say, okay, are y'all gonna pave the road? No, we're gonna do it just like we, squirt the tar and throw rocks down on it. Well, and his response is your road's not ready. Well, we've been out there 19 years. When is the road gonna be ready? Why isn't our road ready? I mean, to me, what they're doing right now is got a very nice space. Why can't it be paved? So, going back to your situation, it might not be travel, but it's just as many houses on our road as it is on the other. And why do they, I mean, if it's a cost savings, why do they get a paved road? Why isn't ours paved?
I agree, and I hear the same question. I hear the same questions, and that I deal with exactly the same questions. I mean, like I said, even the road that I live on, it's asphalted all the way up, and then it turns and goes asphalt on down, and we're mat and sealed. But honestly, I understand it, and I'm not trying to tell you, but we have about 10 or 12 houses down there also on about a 1.5 mile stretch.
Yes.
So I do understand, but I just want you, I'm letting you see the situation is identical in that actually I live on, and but I honestly don't have a issue with it. I understand you do, and I'm not diffusing it at all. I just wanted you to know what I said. And there's it's a lot of situations just like you're talking about, and we hear about it, and I hear from others that that have a road the same way, and it's just so I really can't give you any more answer. I appreciate you coming, and
well, the opportunity is
we'll
now,
look at it.
The opportunity is there now for the Rankin County to step up and do for us what they've done for everybody else. They're at the process right now that they can pave our road, and that's what we asked for. The road is being prepped for it, and they're doing a good job on it. So we asked that the county come out and pave our road just as they've done for everybody else. And I appreciate your time for letting me.
How long a road is it? How long a stretch is it? Do you know?
I'd say from the point that they stop down 1/4 mile, half mile. I mean, I don't know exactly.
Okay.
I would say no more than a 1/2 mile.
Okay. All right. Well,
Okay.
I
Thank you
guess.
very much.
Thank you. Okay. Next we have Miss Lori Reynolds. Good morning.
I'm not very prepared because I just found out about this meeting yesterday.
Oh, we'll just have to put you a later date then.
I live in Barnett Bend 3. Mr. Bishop is aware of the issue that I'm having with a neighbor of mine. I have lived there for 14 years. Basically, I'm speaking mostly for myself. Mm-hmm. But as well as for the rest of the community. I've got a neighbor that has decided that he is going to put in a gravel driveway starting from the front of the road, butting up against the street, going all the way down the side of his house. He's edging it off in the front like a normal concrete driveway would look. And he's planning on putting a 3-foot retaining wall there, filled with gravel, and has got a huge boat that he is planning on parking there. I was leaving the neighborhood today. He has got one of his drinking buddies that is in the first house as you come into Barnett Bend 3 subdivision. I took pictures. I stopped and I took pictures. It just burns me up.
Upsets you, yes.
This boat is sitting right in this guy's yard. And that is the first house you see as you come in our neighborhood. He's planning on putting that boat on the side of the yard. Every time I walk outside, it's going to be gravel. It's going to be retaining wall. It's going to be boat, trailers, all of his. He told me when he moved in that me and him was not going to get along because he was going to have it looking like Bass Pro Shop.
And he was right.
I have been tolerable. I have been
Yeah,
tolerable.
right.
He has parked his little 4-wheelers and ATVs all out in the yard. He had a smaller boat that he parked over on the side. I dealt with that. You know, this is not a normal size, talking about, you know, fishing boat. It has a bed in it. It's taller than me. I cannot see over it. He has got it parked in my front entrance now, and he has every intention of putting that on the side of my house. I do not live at the Reunion or Annandale. You know, we're just little small homes over there.
Right.
But I would say 90% of us, we take care of our property.
Sure.
And everybody on my street, aside from his 2 little drinking buddies, are opposed to it.
Right.
And I don't have time to try to get an overlay law passed. I realized that when we were exempted from that district, the supervisors at the time, I don't know if it was all of y'all or whoever, thought that we were single carports and single driveways. There is not a house in Barnett Bend 3 and Barnett Bend North, which is behind our neighborhood,
Right.
that has a single carport or a single driveway. There are people over there that do have their boats parked over on the side of their driveway. There's some that's even got them parked under the carport. I'm not complaining about that. He is going to make a permanent eyesore that's going to devalue my property, and every time I step outside, I go to my mailbox, retaining wall, gravel. I step on my patio, the same thing. And it's just, you know, it's no end to it. The neighbors are upset over it.
Okay.
I'm more upset over it. I've tried to have a conversation with him. He's used profanities towards me. He drinks a lot. The little small boat that he had been out on the reservoir one evening and was so drunk when he came home, he couldn't back it up in the yard. I've got a fire hydrant that is probably less than 3 feet from where he's doing the retaining wall. His buddy had to come over and help him back it up, you know.
Well, like the sheriff's department needed to come over and help him.
Well, yes, exactly. But this man feels like, you know, he told me, I'm not going to use his language, but in a nice way. He could do whatever on his property that I wanted to do, that he wanted to do. It wasn't any of my business, and
Okay.
he did not have to be courteous to me.
All right. I don't want to, I'm not trying to, kind of need to limit it to about 3 minutes, but I would like to just ask, is there anything in
I'd asked Ms. Reynolds to come today because actually I'd been in contact with our building department, and I don't think so far we've discovered anything that we can do. So Greg, is there anything we can do to help this lady?
Let me jump in. Ms. Reynolds called yesterday. I was at a school function talking to some kids, and so I was out when Ms. Reynolds called. So we haven't had a chance to talk.
Okay.
What I would suggest is let me get with Ms. Reynolds and let's take a look at the issues as it relates to this piece of property. One thing that we may want to look at is if in fact there is a distinction for this particular Barnett Bend development that is different from, significantly different from the other Barnett Bend.
Exactly.
We may want to take a look at
Exactly.
what we're able to do to accommodate that situation.
Yeah.
So if Barnett Bend 3 is more like the other subdivision developments that are a part of the RCD,
Right.
we may want to look at.
It's more like Oak Grove,
Yeah. So
you know.
Okay.
that would be probably the only way that I can think of now that would be an easy solution for that area.
Yeah.
But I think it's going to be incumbent upon Ms. Reynolds to work with her neighbors so that it's clear that a significant majority of the residents there want to be included in the RCD.
Yeah.
Obviously, we know one person who will not want to be.
Right.
But if there is a significant.
Probably three.
Three, yes.
Him and two buddies.
Yes.
But if we get a significant majority of the homeowners there that want to go that route,
Right.
that could be a solution.
Okay.
We'll have to go through the process of amending the zoning regs, and that's a difficult process.
The
Okay.
problem is stopping him doing what he's doing.
But we'll have regulations that can be effective to help get that stopped. Right now, we don't have regulations that can get it stopped.
So if he goes in and he's working on this now to get this done, and the law goes into effect, can you make him remove all of that?
Most likely not, but we can control his use of the property from that point forward, okay?
What?
The
Would
hard
you
issue
like to
here, and
see a picture of the boat?
You and I, we're gonna talk about it. I
Okay.
promise. You'll have an opportunity
Okay.
to visit with me about it. I want to try to move on, so we've got other things we got to take care of.
Okay.
Well, yeah, because we're not cutting you off at all, but that's where we are. You need to, let's start here and the two of you get together.
I understand.
Kind of there,
I'm
yeah.
just upset.
Oh, I understand.
And I
do.
know all of this is going to be
Right.
done before y'all can get anything
Right.
done.
And I understand you being upset, and I think it was clear, and I could relate very well to
One of
why
the
you would
things
be,
that
so.
It's difficult in this situation because typically those kinds of specific land uses are controlled through restrictive covenants. I suspect that what has happened here is either those restrictive covenants never were put in place, or they haven't been enforced and they've been allowed to lapse.
Right.
There's a number of reasons why, but typically those kinds of land uses where you're talking about vehicles in the front yard and side yard and how you construct your driveway, those are typically issues that are handled by restrictive covenants.
Well, the gravel really is what caught my attention.
Agreed. And most of the time, that would be a restrictive covenant issue. And
Right.
those are
And he's
not-
taken up over 50% of his yard by doing that.
We hopefully will be able to address some of those by
Let's-
having a move towards the RCD. being
Well,
Okay.
and let's not forget about the retaining wall to make sure that no water is placed upon, pushed over on you guys too,
Very
for
nice.
flooding or whatever.
I'm not just worried about that. I'm worried about, and a friend of mine brought this up the other night, when it comes gully washers.
Right.
Like we've had, for, a while,
Right.
a month or so ago. The gravel, and even, Mr.
Right.
Bishop brought up, getting over in my yard. I
Right.
have a professional landscaper that comes by and cuts my grass. And, I worry about him hitting the
Right.
gravel
Right.
and possibly breaking out a window or damaging
Right.
the neighbor's boat, and him coming and saying, well, you did this on purpose, and he's the type that he would do
Yeah.
that.
Okay.
I mean, he's just a very angry person. I have, I just feel like I have no rights. There's nothing I can do because
Right.
there's not a covenants over there, and everybody assumed we were single carports and single driveways when they exempted us, and now I'm being punished for it.
Right. Well, we'll let he's got your, Mr. Slay has your number and all, and
You do?
we'll let him get together with you and see what we can do. So,
Okay.
Okay.
I appreciate your time. I hope you
All
can
right.
help me.
And
Thank
look, you were very well prepared.
Hey, I got pictures taken.
Okay.
Thank you.
Thank you.
Thank you, ma'am.
I'm gonna leave now.
Okay, moving on, old business. They have a motion to approve.
Motion approved, May 4th, 2015 minutes.
Second.
Motion approved, Mr. Wilcox, second, Mr. Keith. Any discussion? All in favor say aye.
Aye.
All opposed? Consent agenda.
I have a question. The 125,000 increase, or 136, it was $100-something,000, and it said it was an increase. Why are we doing that?
Youth court,
Yeah.
they got a grant. You know, last year their department was cut because they were waiting on a grant that they didn't know if they would get or not, and the DPS grant came through, and so they're amending the line items that it would pay
Oh, okay.
for.
All right.
That's the amount of the grant.
Okay.
And I just had one thing just bring up as a discussion. Just I noticed under C, under dues and conferences, is that going to be kosher, okay, since one of them is a candidate for that office? Is that?
Where's that at?
I don't think it matters.
Item 2C,
Under the
top
coroner.
top of the second page of your consent.
Yeah,
Yes, he is deputy coroner.
He's a deputy coroner.
yeah. I mean, I'm just,
By virtue of his office.
I just want something to come up.
Well, that's
Okay.
probably no different if I want to go to conferences.
May not.
I mean,
You're not going.
You not gonna let me go if I want?
You're not a deputy. You're not an assistant. Okay,
I'm not going
no.
though.
I just wanted to, I just had read over that and just wanted to make sure it wasn't something, but that's fine. I just wanted to bring it out, okay?
Motion to approve.
Okay, have a motion to approve, Mr. Bishop.
Second.
Second, Mr. Johnson. Any more discussion? All in favor say aye.
Aye.
All opposed? Okay, John Sullivan. Good morning.
Morning. First item, petition change the assessment of 2014 real and personal property assessments.
Motion approved.
Second.
Motion approved, Mr. Wilcox, second, Mr. Johnson. Any discussion? All in favor say aye.
Aye.
All opposed?
Oh,
Item-
yeah. We may not let him go.
Yeah.
Yeah,
Item
what do
B,
you want to do?
allow me to go to Biloxi to my conference.
Motion to approve.
Second.
All right, motion approved, Mr. Bishop, second, Mr. Wilcox. Any more discussion? All in favor say aye.
Aye.
All opposed?
Item C, void the 2010 and 11 tax sale for PIN number 26970 and request the tax collector to generate a corrected tax statement.
Motion approved.
Second.
Motion approved, Mr. Bishop, second, Mr. Keith. Any
Why-
discussion?
Now, why do we got it listed as Chancery Clerk?
Since it's gone through the tax sale already,
Yeah.
all the redemptions is handled through the Chancery Clerk's office.
Oh, okay.
So he handles the,
Okay. Well, I mean, we just normally don't have items under
right.
that, so,
There you go, on a tax collector too.
yeah.
Okay, I had a motion and a second. Any more discussion? All in favor say aye.
Aye.
All opposed? All right.
And item D,
Oh, you just filling in for everybody.
I am. I wear so many hats. Void the 2012 tax sale for PIN numbers 18589 and 16368.
Motion approved.
So-
Motion approved, Mr. Wilcox, second, Mr. Johnson. Any discussion? All in favor say aye.
Aye.
All opposed? Okay, thank you.
y'all.
Thank you.
See you tonight. What time is that? Congratulations. Good morning, Bridget.
Good morning. How are y'all doing?
Good.
Fine.
This morning, I'm requesting approval of a contract with Expressive Lawn Care for 12 months to maintain the county properties.
Motion to approve.
Second.
Motion approved, Mr. Bishop, second, Mr. Wilcox. Any discussion? I have, is that the one that's been doing it, or is this a new one?
They are the one that's been doing it. I sent out proposals about 10 different people. I keep a running file of who was interested, but this is the only proposal we received.
Huh, okay. All right. All in favor say aye.
Aye.
All opposed? Hey, Mr. Parker.
Thank you, Mr. President. I have two items. The first item is request approval of a utility permit for AT&T to construct a new pole on Midway Road.
Motion approved.
Second.
Motion approved by Mr. Wilcox, second Mr. Bishop. Any discussion? All in favor say aye.
Aye.
All opposed?
Thank you. The next item is request approval of a utility permit for Southern Pine Electric Power Association to construct a single-phase primary line along and across Monterey Road. It's installed between a half-mile north of Butler Place.
Motion approved.
Second.
Motion approved, Mr. Wilcox, second Mr. Bishop. Any discussion? Is this just a new line, or?
Yes, sir.
Really?
Yes, sir.
I move, okay. Well,
Do we, I think I asked you last time, whenever we have stuff like that, do we follow up behind them, I guess, as far as the road crew, making sure if they trim any limbs and all this stuff, if we
Pick up the debris and so forth.
Yes, they make sure all this?
Yes, sir.
Okay.
Okay. All in favor say aye.
Aye.
All opposed?
Thank you.
Thank you. Hey, I noticed, where you coming up, Craig. Dale, I know you're not on here, but I just wanted to let you know, with Westbrook, are you in the building? Okay, there you are. I have had several phone calls, thanking and complimenting on some of the striping that, been going on. And you're probably familiar with some of the ones I'm talking about, so I just want to let you know. Thank you.
And I've had several compliments still across the board from Mr. Westbrooks and his crew.
You think?
Good morning, gentlemen.
Good morning.
The first three items under my section A, B, and C are to set public hearings on the same date, May 28th at 9 a.m. First one is for the Harold Bigby nuisance property. That's a District 1 parcel. The public hearing on the Michael Clark 102 Catherine Drive, District 3, and a hearing on the Tanya Temple 106 Arrowhead Drive, District 3. I would request a motion to set items A, B, and C for hearing May 28, 9 a.m.
I'll make that motion.
Second.
Motion to set these public hearings by Mr. Johnson, second Mr. Wilcox. Any discussion? All in favor say aye.
Aye.
All opposed?
The next item, Mr. President, item D, under public hearings, is a public hearing on the Central Rankin Water Association conditional use request, 832 7th Day Road, District 1. Central Rankin Water is requesting a conditional use permit to construct a 768 square foot office building at 832 7th Day Road. This is a 1.70 acre parcel with zoning designation RE1A. Planning Commission will meet on no, that's already happened, hasn't it?
Mm-hmm.
So we have the public hearing today, May 15th.
Right.
This time we'll open that public hearing. I'll ask if there's anyone here to speak in opposition to the Central Rankin Water Association conditional use request. Is there anyone? Mr. President, I don't see anyone here to speak in opposition to that matter. We'll close that public hearing and be appropriate to take action.
I make a motion to approve.
Second.
Motion by myself, second Mr. Johnson. Any discussion? All in favor say aye.
Aye.
All opposed? Thank you.
Mr. President, next item, and at this time we'll open a public hearing on the Capturion Network LLC dimensional variance request, 225 Avalon Circle, Lot 2, Avalon Center. This is District 2 parcel with which everyone is familiar. Capturion Network LLC is requesting a dimensional variance for an LED billboard on Lot 2 of Avalon Center. The sign ordinance states that no permitted sign will be placed nearer than 1,500 feet from the boundary line of any lot of a platted subdivision. The proposed billboard would be closer than 1,500 feet to 6 platted subdivisions. So the applicant has requested a dimensional variance from that setback requirement. This time we will open the public hearing, and the way I would like to address this, we have representatives of Capturion Network here today to speak. I think it'd be appropriate to give them an opportunity to visit with the board about some recent issues that have surfaced and address those to the board. We will also have an opportunity for those who are here to speak in opposition to the application to speak as well. And so we will do our best to try to address that as we move forward. In quick summation, the applicant, this is just a brief history about this matter. Back in 2011, the applicant came forward with a request for a dimensional variance to install the billboard on Lot 2 of Avalon Center. That matter went through the process, and in 2012, the board actually conducted a public hearing on that matter. At that time, the board in place at the time voted to deny the request for the dimensional variance. That matter was appealed under Mississippi law and it goes to the Rankin County Circuit Court. The court reviewed all of the documentation and the submissions and determined that there was insufficient information before the court at the time to determine the exact basis for the board's decision, and so the court remanded the matter to the board for further consideration. There has not been action on that application since it was remanded. In the intervening period of time, the board adopted what is known as the Reservoir Community District. The Reservoir Community District now regulates billboard signs within the district. It prohibits them outright. So this application that is before you is the last of the Mohicans. There will be no more billboards within the RCD because those are prohibited within the RCD. This relates back to the point in time that the court remanded the matter to the board, which is why it's here before you, all right? And so the applicant has moved that process forward. The board has set the hearing for today by motion that was seconded and passed by a majority of the board to move the matter forward. So it's really at the board's impetus that we are here today for this public hearing on this matter. At this time, I would ask whomever is going to speak on behalf of Capturion Networks to come forward. This is Mr. Brad Reeves. He is a lawyer representing Capturion. Brad, if you'll.
Thank you, Craig. Board members, we're here this morning. I just want to speak initially on behalf of Capturion, my client, and make sure, I believe you're aware of litigation. I spoke to Mr. Slay again about that. That's recently been filed. It come to our attention over the last few months that some of the opposition to this variance has been in reference to some subdivision covenants. And this isn't a residential subdivision, but the commercial subdivision, Avalon Center, where this billboard would be located. Some of the landowners there have raised the issue potentially about some covenants, and the covenants reference an architectural review committee that we have recently filed. Capturion, my client, has filed a declaratory action in Rankin County Chancery Court asking to clarify that issue because it's not really clear. The developer has passed away. There's a number of ambiguities and questions to be answered. We don't know who the architectural review committee is. The last few months we've written letters requesting to appear before the architectural review committee to find out who they are, to find out if they have any minutes. We don't even know any of that information. So again, we've asked the Rankin County Chancery Court to make a decision and fill us in on that. My primary concern is that if we move forward with this hearing today, we hear a number of issues in opposition, and that becomes kind of a sidetrack issue when in the fact, if the court decides this is a non-issue, then we're not going to prejudice my client by hearing about something that may not even be an issue. So again, Mr. Slay did a great job of kind of bringing us up to the history. I know y'all hate to hear this from the attorney side, but it's our position at this point, this is not ripe to come before the board. We have an issue that's come up, and we feel like, hey, let's go ahead and take care of this, let the court address it or resolve. The parties can, voluntarily resolve, may not need the court, to figure out exactly what's going on with these restrictive covenants in the subdivision. Then once we take care of that, then we can come back before the board and resolve that matter. So all that being said, we're here today asking to continue this matter, and we would request that you do that. I can try and answer any questions you may have, but certainly feel like this lawsuit being filed and this issue may bring up some issues that would be handled in the lawsuit rather than letting that be opposition here that would then prejudice my client or be something that really isn't even an issue at all that the court can decide. So,
well, I was wondering why you were back here today myself, if with this still being out there.
How long a period of time are we talking about?
Well, I'm hoping that this is, we've been writing letters the last few months, trying to get it resolved. I'm hoping now that with this lawsuit, whether the court can decide it here in the near future or the parties can voluntarily resolve it. Sometimes that might be all it takes is us to get together and figure out everybody's on the same page or where our differences are. So I think in a few months we could get this resolved.
When did y'all find out from the developers, I guess, that this was a problem as far as from the business piece of it?
Yeah, it's come up, and I'm let me just say my representation's been limited. I have not been the lawyers from this on day one.
Right.
But with my involvement, I've been known about the last few months. We've sent some letters and some other attorneys on behalf of my client asking an attorney representing the subdivision, the Avalon Center, asking, where are we? What do we need to do to appear before this architectural review committee? Because we don't even know who it is, where they meet, who the members are, and that type of thing. So again, this isn't something we're just showing up at the 11th hour. Included in our complaint with that was letters and documentation where we've been trying to say, what do we need to do? What's the story on this architectural review committee? How do we appear before it? Who are the members? That type of thing. And I just, again, know it's not always fun, and I know y'all don't like to hear this from Mr. Slay a lot of times, but sometimes we need to make sure, that this is done right. That would be, our recommendation, our request, that we make sure we go through the hoops at the right time so that we don't have to have this hearing twice or go back and undo something that's already been done.
Kind of like cart before the horse.
Exactly.
Yeah. I really don't see how I could rule on, we have a honest decision without knowing what the court did. We've been in situations before where, something was pending from that's held up in the court that we've had to wait on, and I feel like this is the same one. That's the same situation. It's the reason I wondered why we were having this hearing today.
Well, we know we can't vote on this knowingly that putting someone in jeopardy of a lawsuit. Our attorneys already advised us of that. So, but I'm willing to grant some time, but I don't know if this is the appropriate time to do that or not.
I agree.
Yeah, give us a little bit of update on what.
A couple of facts that would be important in your deliberation on this issue. There are a number of issues at play that address the issue of whether or not the billboard should or should not be allowed. There are a number of issues. One of those is the existence of a set of restrictive covenants that is a private agreement between landowners within a defined area. It's a private agreement. This board, Rankin County, does not enforce private agreements among landowners. However, our policy is and has been, since I've been with the board, that to allow a land use that we know on the front end violates a private agreement concerning land use is to place those land users in jeopardy of litigation. That is, we force their hand to actually enforce their restrictive covenants. So by the county saying you can do this on that piece of property, when we know on the front end that there is a set of restrictive covenants that says you can't do that, you can understand how that is contradictory. We generally would not allow land use that we know on the front end violates restrictive covenants. And that is where the applicant stands today.
Yeah.
The applicant stands in the position that there is a set of restrictive covenants that applies to Avalon Center lot owners. There's 16 of those. The restrictive covenants say you don't put a board, a sign on a lot within this defined boundary unless it meets certain very tightly controlled requirements. The billboard that is proposed does not meet those requirements. It violates those requirements. Okay? So by moving forward today, and if the board were to decide it is okay for the applicant to install a billboard there, while there is a restrictive covenant that says no billboard, then the board will be allowing a use that it knows on the front end violates a private agreement, okay? What you just heard from Mr. Reeves is that Capturion, has filed a lawsuit. It's filed. We have a copy of the filed lawsuit. You've seen that lawsuit. And it says Capturion believes that the restrictive covenants are not enforceable, that they should be voided, that a court should declare them to be unenforceable and void, which would, if that were the case, if a court took Capturion's position and voided the restrictive covenants, then this board would not be reviewing the application from the standpoint of does it violate the restrictive covenants. You would have a court order, again, assuming that that's the position the court takes, you would have a court order that says, all right, Board of Supervisors, you can ignore the restrictive covenants now. That is no longer an issue. As we stand here today to review the application, we don't know the answer because the court has not spoken on the issue of whether or not the restrictive covenants are valid. Okay?
I'm not so sure that was even, I don't know if that was even brought up 2-3 years ago about those covenants.
It was discussed, but only in limited fashion.
Right. Not to this extreme. I think that it was because it did not meet the county's.
Right. And that goes back to my earlier point. And I think it's important to understand. The restrictive covenants issue is one of many considerations that the board can make concerning the application. It's just one. The short answer is, if this board is of a mind to know the answer to that question, then you are not in a position to move forward today because we don't have the answer to that question.
Right.
And the only way we can get an answer to that question is for a court, the court in which the case has been filed and served, that court to determine that question. Do the restrictive covenants apply or not? At the end of the day, once that question is answered, the board must then move to a number of other considerations.
Right.
Okay? So just because a court says the restrictive covenants do not apply, that does not mean that Capturion gets a billboard. The board still has the ability to address all of the other considerations under our sign ordinance. Okay? So you do have the option to simply say, if you chose to do so, you have the option to say whether or not the restrictive covenants apply or not. We're not concerned. We're going to move forward and evaluate the application without regard to that. We'll even assume that they don't apply. Is the applicant, even with the unenforceability of those restrictive covenants, is the applicant entitled to move forward with this application on all of the other considerations? Just forget the restrictive covenants, let it go. Is the applicant entitled to a dimensional variance without regard to that? So those are your options. If the board chooses to do so, it can continue the hearing until a time, give the applicant time to get a court order in place, and then proceed with the review of the application, or move forward today with consideration of the application just as it stands. Okay?
I don't see how we can make, I mean, for myself, I don't see how we can make any decision until we have all the answers. Kind of like a sale pending, or in a domain situation where we say the value of the property is one thing, but we have to wait till the court decides and tells us what they decide the value is. So I mean, I couldn't make a honest decision today anyway.
Well, regardless of how the court rules on the lawsuit that's been filed, it is prohibited in the Reservoir Community District. So I don't see how it's
Actually, Walter, the board is forced to review the application under the old sign ordinance.
Right, because it was grandfathered in before.
And that's because Judge Empfinger's order is a remand of the initial application to the court.
But the problem being is, it was turned down 2-3 years ago.
2012.
Right. It was turned down then because of, now I wish my memory was that great, of what the reason why we turned it down. One of the reasons why I know that I voted no against it was because it did not meet our covenants. So
Our ordinance.
Our
Yes, sir.
ordinance, I'm sorry, our ordinance. So I don't think that our ordinance has changed any.
No, I think.
No, it hasn't, because the 2012 sign ordinance is exactly what it was in 2012.
Exactly.
So what you're reviewing today is the language of the sign ordinance.
So I'm kind of
as
like
it was in
Walter,
place.
does that really mean anything as far as it going to court? What the outcome either or, would that mean anything?
Quickly to review, and hopefully I'm trying to be as clear as I can about it. If you can imagine, there's a line of about 8 or 10 different considerations before the board. The restrictive covenant is one of 10. Okay? So if the issue of the restrictive covenants, item 1, is dealt with by the court, and the court finds that item 1 is not a consideration, they are not enforceable, you have 9 remaining considerations that you still must go through to determine whether or not the application should be granted. Okay?
Well, I'll make it easy. I want to move that we continue this till after it's settled in court.
My second.
Well, we're not even out of public hearing yet, are we?
Well, the public hearing is still open and needs to remain open. I think Jay's motion is proper at this stage, because there would be no need to continue the public hearing if the if the majority of the board believes that the continuance should be granted. We would simply hold the public hearing in abeyance until such time as the board decides to bring it back up for hearing.
Right. I got a motion and a second. All in favor say aye.
Nope, I gotta ask questions.
Okay, any discussion?
Yeah, I've got a discussion. So
Okay.
what, how long are we gonna be deliberating on this? So when is the court gonna bring this back up?
It's completely at the discretion of the board as to when the board chooses to bring this matter back up.
No, I'm talking about when is the court going to deal with
That's
this?
an impossible question to answer, Greg. That's going to be controlled by the court's docket. It's going to be controlled in large measure by the parties themselves. The lawsuit was just recently filed. There's a 30-day period of service of process. The applicant has at least 30 days and can ask for more time to get service of process of the lawsuit upon the named defendants. Until they're served, they are not. There is no way that the issues can be joined in court. Okay, so it's impossible to know the answer to that question. I would suggest strongly to you that at least a minimum of 6 months from today, that would be an absolute minimum of time that would be required for a court to consider the question before it.
Okay.
Now, it is one for declaratory action. What that means is essentially the court is being asked to rule on an issue of black and white letters on a page. To my knowledge, y'all are not asking for any sort of monetary damages or anything like that. So it's just a pure declaratory judgment action. So basically what happens in that respect is the parties have an opportunity to agree or disagree on what the facts before the court are, assuming that there would not be a lot of facts in dispute. The court could take it up and render a judgment fairly quickly. It's a chancery court matter, so it's non-jury, so you would expect that the court would have an opportunity to take that up and speak to it. But we can't control the court's docket here. We can't put time limitations on how long it takes for the
But no
chancery
matter
court to
what
do
the
it.
court says, it's still a county ordinance issue.
It's absolutely, it will be. One of the bases that I would anticipate that this board would find in determining whether or not the application is valid or should be granted or denied, one of those bases will be the issue of the restrictive covenant. Okay? So if that is no longer a basis for denial or granting, then it should simply not be spoken of. And you could do that today. You could simply ignore that issue and move on to the other issues and address the application, ignoring the restrictive covenant issue.
Well, the way it's been going here lately, it won't be this board.
Won't be what?
From
It
a
won't
timing,
be.
from
Exactly.
a timing perspective, Greg, it would surprise me if this matter were ripe to come before the board.
Right.
Before the end of the year.
Right.
It would surprise me.
Before, if it did?
It would surprise me if it did.
At least we have clarity on everything.
Okay.
That's my
I think we're looking at longer than 6 months. I gave you an absolute minimum in my mind. And
That's
in
what
my
I'm saying.
opinion.
I don't foresee it coming before this board, the existing board. Okay. That's all the question I have.
Okay. We had a motion, second. All in favor say aye.
Aye.
Aye. All opposed?
Nay.
Nay.
If I may then, we will continue with the public hearing. Mr. President, just from the standpoint of clarification, Brad, did you have anything else that you needed to add on behalf of the applicant at this stage?
I don't think so. I think that's it.
Okay.
Thank y'all.
Thank you.
And so at this point, I would ask, is there anyone here to, Leonard, did you need to speak to the board? Okay. I'm sorry. Mr. President, with your indulgence, the applicant,
Okay.
the representative of Capturion, Mr. Busby, is here. And I think it'd be appropriate to give him an opportunity to address
Sure.
the board.
Sure. Josh, you need some help?
Mr. Chairman, is that okay if I bring?
Certainly. Don't break, drop a toe on your toe.
That's Mr. President.
Yes, I'll be fine.
No, you're fine. You're fine.
How you?
All right.
Thank you for the book.
No, we're not going through this page by page, are we?
No, sir.
Okay.
I do have a jump drive if they would like to put it on the screen.
We didn't bring our computers, Dave.
Okay. In going through the ordinance, the sign ordinance that we're presently under, we met every stipulation, being 15-foot setback, 515 foot from an existing billboard, 100 foot from an intersecting road. The only thing that we did not meet was being 1,500 foot from a subdivision. If you'll go to, let me get my notes, I'm sorry.
I've seen that picture.
There is some existing boards. There is an existing board that was approved by a board back in 2008 to allow a digital board to be moved up 171 foot, that they got a permit and they got approval by the board to allow this digital billboard to be placed 30 foot within Cox Avenue, 1 foot within residential platted subdivision. And I just make that, and these are all in the document as far as going through the application. You can see the maps of it, of what we had. And what, I just didn't want to be deprived that other landowners and other billboard companies have, because there's an existing billboard to the north of us and there's an existing billboard to the south at Old Fanning Road that has came before with that didn't meet any of the restriction. Well, they met some of them, but they didn't meet the platted subdivision and they didn't meet the other one. But the board still has the option to move forward. But what I'm really concerned about is what we offer and want to offer to the subdivision and to the community. In allowing us, we are very community oriented, just like yesterday. Both the families of the police officers have, and we've had over 22,000 hits on our Facebook honoring these two officers. We had them playing up on all of our boards. We offered to Hines Community College that's in Rankin County advertising for young businesses to come out, and Dr. Muse has even stated that in a letter to you. Mm-hmm. We also have in your booklets a letter from the Pearl Chamber of Commerce where we advertise young businesses. We're wanting to offer customers a variety of pricing where if a florist has $200 if they want to rent a digital billboard, they could rent a digital billboard for a certain amount of time versus signing a long-time contract. This gives all small businesses a chance to advertise. We do fundraisers. The Rankin County, a high school in Rankin County, the band director calls me up and says, we're doing a fundraiser. We can't afford to put an ad up there. Will you put an ad up there? We're trying to go out to California. We do this at no charge to the schools. Just 2 days ago, the Board of County School Board approved Capturian. We're doing a brand new football video board. They didn't have the funds to do it. I personally went out and got a naming rights company in Rankin County to sponsor this, and it was approved 2 nights ago. We're involved. I'm a part of this community. I want to help, and we honor Alex Hodge, every sheriff, every chief, Tyrone Stewart, throughout all the different counties, down in Wiggins, Miss Pam Clark, the mayor over at Florence. We represent them at any time they have an event. At no charge, we put their message up there. One big thing with the police departments is before you can go Amber Alert, you have to wait 24 hours. Well, those officers here, even in Rankin County, if they come to us and we got a child missing, within minutes we can put it up because we don't have to wait on Amber Alert. You don't have to wait 24 hours. Very important. We don't do adult entertainment advertising. We want to be able to provide something for small businesses as well as the big businesses to make money as it as well. But I wanted you to know what we're doing. In your book, you'll see where we had the 2 officers that are posted throughout Pearl, Rankin County, and over in Hines County, down in McGee, down through Wiggins, and in Hattiesburg. And I've even got texts today. I've got over 22,000 kids just telling me thank you. And I want to do that. I want to be part of it. If you have a child in this neighborhood, and I don't know who all comes into the reservoir, and a lot of them don't live there, but who knows what would happen. And it wouldn't be but 1 second that we would have their face up there to help. That's what we're about. And I'm not, it's not, it is a simple, but it's really true. That's what God's driven me to do this. This is my heart. This is where I want to be. This is how I want to help small business. I'm not a big public company. I am not. I've even offered, if we've got a bike trail. If they ride bikes on the thing, I would put up an ad to be careful driving. There are no wrecks out there that this other LED board is created for as light changing. We're required to hold them for 8 seconds. Everything's done this way. We went out through the subdivision. The Covenants Homeowners Association, there was an email blast that's in your thing that went out that stated that we were going to put this LED board right at the entrance of Avalon subdivision. Well, that wasn't the case at the time back in 2012. We even had Mr. Dean that come before this board and said that he was not aware of that, and his wife had signed the thing, but he was reversing it because they thought it was under the impression of where it's at. But I think now everybody knows where it's located. We have over 186 signatures that we walked through and told them and explained to these small businesses. I just want to have the same opportunity that my competitor has had down on another piece of property, with being closer to an intersecting road, being 1 foot from that would have mean they had to get a variance of 1,499 feet. I'm 420 feet. I'm 1,080 something feet from a platted subdivision, the first one. And I've got maps in there of their circled as well. Mm-hmm. We want to be a part. The community college, the small businesses that come out, the kids that we're helping over here in Rankin County, Northwest Rankin, they don't have the kind of funds that private schools have. So they called Leonard up. I don't mean to be arrogant, but Busby Companies, Capturian, and we went out and pre-sold this, and this year they're going to have a football bowl. And those parents in Rankin County, at Northwest Rankin, we're going to have a bigger and better video board than any of the schools in Jackson, high schools. This is happening right now. The school board's already voted on it. These things help. They help tell people. We support our sheriffs and our police department. This is the prayer week. This is what I do. I don't know that big public companies do it. Maybe they do. I don't know. But I know what I do, and I know how I'm convicted by it. I asked the board, in doing this, we had the landowner write certified letters months ago, never replies from the covenants to answer those questions. Even had my attorney write a letter. We got one response back from Mr. Thomas Starling. I stand corrected, his letter's in here, that he has no minutes of the covenants, if we want to address that part of it. But I am here to tell you, this is going to benefit. This is a 5-lane road. You got 20-something thousand traffic there. We can slow them down. We can help. Something to happen that we want to be a part of it. We want to help the flyer shop that wants to advertise. We want to help the small people that doesn't have, as well as the big customers. I haven't went over every one of the items in here, but I would like to submit them showing all of our pictures of everything, of the dimensions and what's there and what's been granted. I'm asking for way less that's already been approved, but you can still, I understand, not approve it. It would really help Hines Community College. It would help the community. It would help Rankin County Police and Sheriff Departments here. It would help Rankin County presently. We work with the chamber. We don't charge them, and I know that Rankin County rents billboards, digital billboards for small businesses. I would love to help in that way. I'm here to help.
And I will add to it right quick. I know in the Florence community you have been a very good steward to help the community on many things, and I'll say that publicly. I am aware of that. Thank you.
Thank you. If there's any questions.
You want to make this a part of the record, is that?
Yeah, I would like for one of their books would be better, Craig, because it's really outlined in numerical order.
We'll make sure
I got
that
one.
This,
I got another one.
Okay, we'll make sure that this is a part of the official record of the public hearing.
Again, I just want to tell you how we helped them raise money, and Matt Little over at Pearl, they're out raising money, and these ads helped them get their band to go. Just like how we honored the school here.
Right.
Picture their picture up there.
Right.
I would have loved to have done that.
Okay. Thank you.
Thank you.
Thank you, sir.
Mr. President, this time, with the board's prerogative, it'd be appropriate to ask for those who are in opposition.
Correct.
I would simply ask that we not do a lot of repetitious comments, if at all possible. But I will, at this time, I'll allow whomever is going to speak in opposition to the bill board to come forward. Please tell the board your name and address. Thank you.
Thank you. My name is Jim Snyder. I live in Avalon subdivision at 503 Bristol Way. I work in Avalon Center. I have the Ride South bike shop. You may have seen on some of our bikes riding around this past week.
Yeah, they were actually in the median. The bike got run over.
Well, they may have been, some of the drivers could have been looking at a billboard up there and not seeing it. Now, what I like to say, and I have lots of information, I'm going to keep it short, but I just want to speak first. And I'm telling you, I'm up here because my attorney said he should come first, but I've got to give you guys this information.
Sure.
It's important. I'm starting off with deja vu. We've done this all over again. I was here 2.5 years ago. I brought forth a petition that I have one very similar to it today, signed by all but 2 of the property owners in Avalon Center, saying that they oppose any billboard sign in Avalon Center because of many reasons. Because it was against the ordinance that you guys have made. because it was against the covenants that you brought up and we've discussed. And you may remember Mr. Morris, who was here, who owns the property, called me a liar, and right here. And what I'm here today to tell you is that no, I speak the truth. I am the co-chairman of the Avalon Center Architectural Review Board. And the other member, the board member, is Mr. Tom Starling. I don't know if he's here or not. Right. Oh, right. We are the co-chairman. Another member is Mr. Glenn Mitchell and Mr. Mike Ryle, who said that he had to leave. He couldn't listen to the previous comments. He had to go. No, I speak the truth. I knew Dr. Hugh Ward, who Hugh Ward Boulevard is named after. I helped him design the entrance for Avalon Center. I was signatory to the plat development. I was one of the first property owners. I built a engineering business there and subsequently built a bicycle business and owned 3 other properties in Avalon Center, as well as properties in Avalon subdivision. The truth is, the gentleman that called me a liar has been, under this circumstance, a nuisance to Rankin County. This has been going on. He's the one who's leased the property to Mr. Busby, and in fact, Rankin County called him that and put him in jail and told him to clean up his property. Avalon Center covenants don't allow people to park trucks and construction vehicles there. So we wrote letters, Mr. Starling wrote letters, and we asked him to remove that. We were ready to bring a lawsuit against him, but there was a pending legislation, or at least pending ordinance. I don't know what you call it, but he was asking you guys to give a deviation or a variance at that time. So we said, no, y'all handle it. So you did. I came before you, and everyone here should remember that, except Mr. Keith, when Mr. Wood Brown was sitting there. And you voted, and you listened to me, and I said, this is dangerous. This is distractive. It is against the covenants. It is against the ordinance. You made the ordinance. There's nothing safe about this. These billboards belong on interstates. They don't belong where subdivisions are. They don't belong where people are going to be distracted and run over our bicyclists who are riding down the lane, the proper lane, as you designed this place to do. It's awesome that we have this great facility. So during that time, I have been approached with a bribe by Mr. Busby, who said, look, free advertising for you. He even mentioned property for me. I said no. I have been threatened with a lawsuit, and I speak the truth. It has come to pass today, yesterday. There's a lawsuit trying to devalue our protective covenants. Dr. Ward was the protective covenant of Avalon Center. When he died, tragically, his wife and nephew, Steve Baker, I don't know if Steve's here today, did he make it? No, I've asked him to come. But he took over the role of the Architectural Review Committee. Not committee, excuse me, the Architectural Review Board. And he was the one who I went to when I built my shop. And I said, Steve, is this okay? Does it meet your requirements? And he said, yes, Jim, it does. Great, you build it. And that was the sum total of the documentation. There are no books. There are no documents. There's nothing that these lawyers are trying to get to disallow covenants. There's an understanding among a close-knit community of 16 property owners that we
want the place to be first class. A big billboard will devalue our property. It will not be first class. It will distract drivers. I may be the one getting killed. Some of you may have people out there getting hit by somebody looking at a billboard. Interestingly enough, the gentleman who, he's back here, he came into my office trying to be my friend and said, Mr. Snyder, we've done studies that these billboards are not distracting. I looked at him and I said, then why put them up? Billboards are distracting. They're designed to distract you from your driving. That's the whole purpose of them. So yes, they distract you. They cause you to not think about driving or riding or walking or whatever you're doing out there on Old Fannin. The truth is, the courts want no part of this. Mr. Slate said as much the last time I was here. He said the courts have thrown it back to you guys. They don't want to deal with it. They've dealt with Mr. Morris before. He came into his own appeal and he claimed no contest because he didn't want to be guilty. They don't want to deal with it anymore. The truth is, the people behind me have asked you again to disallow this. You've made your own covenant, your own ordinances. Just adhere to them, and that's what we asked before. You were smart in doing that. Just adhere to it. We're concerned about the safety. We're concerned about the distractions and the property value. Distracted drivers kill. We know that. It happens all the time. We have friends who have been killed by distracted drivers. Been on a cell phone, looking at a billboard. It's just about the same. I love Rankin County. We had our recumbent rally here a couple of weeks ago. We brought people here from all over the world, basically. And they loved Rankin County. They liked the fact that it's bicycle friendly. And we own 6 properties here. We pay lots of taxes. We vote. The truth is, Avalon Center has protective covenants that do not allow anything like this. They are in force. They run with the land. There's no way to get rid of them unless 60% of the property owners vote that they're not allowed. In fact, I have 88% of the property owners on this petition that Renee has, I think the original, do you not? That I gave to Mr. Keith. This is a copy. And I'd like for this to be in the minutes, and I'd like for my comments to be in the minutes, please.
They're being recorded.
Good. 2.5 years ago, Mr. Larry Swales left and made copies for me. We discussed covenants. I brought them. He made copies. We made copies of the petition. Somehow they did not get put in the minutes. So maybe that's why we're here today. I don't know. But nevertheless, I speak the truth that they go with the land. And I'm just going to close in saying that, look, all 5 of you know the truth. I know you do. All we're asking you, and I want my friends here to talk. I want Mr. Ross Branning. I want Lynn Mitchell, my wife Lane, Tom Starling, Charles Stewart at Avalon, representing Avalon subdivision. I want them to talk. This is a public hearing. I want you to hear them. You've heard these other guys for ad infinitum, or whatever that word is. Now, listen to us and understand and do your job so we can go home and do our job in peace. Thank you.
Thank you.
I'm Tom Starling, the attorney for the Avalon residents, and I did just want to make sure that this petition is part of the records, and we just give her another copy of this form. This board is bound by some of the benchmark decisions that we face every day when you take action, especially in zoning matters, that there has to have been a change in the character of the neighborhood to justify what they're asking. If there's a public need for what they want. None of that is present here. You're bound to hear the residents who are directly affected by this. Over 88% have said, we want our subdivision to remain the way it is, no billboards. And we ask that you vote the application down.
Thank you, sir.
I'd be glad for y'all to speak, but if, like Mr. Slay had referred to, if it's the same thing, each of you, I wish you, because of the time, you know, think about that. Sure. Welcome to, but not just to say the same thing.
Certainly.
Thank you.
Charles Stewart, S-T-E-W-A-R-T. And I've been a Avalon resident for 14 years, and obviously Avalon Center is adjacent to Avalon subdivision. And also for much of that time, I worked for Homeland Neighborhood Management. We manage adjacent subdivisions, Avalon, Pine Brook, the Pinelands, also known as Turtle Ridge, Farmington Station as well. Roughly 1,500 homes, and of course we're opposed to it. We see it as a distraction. It gets a lot of attention, which is what a billboard wants, but that's not good when you're driving. We see it as a hazard. And the other one that's about 2 miles away, has been referred to, is one that nearby has a field with equipment in it, if you've seen that one, and it's adjacent to the subdivision that was discussed earlier, Barnett Bend 3, and that doesn't look so good. I'm in charge of code enforcement again in these subdivisions, and that's a problem that they have that they're lacking. So we don't want it to look like that. That's maybe appropriate in that area that was described by the lady that left earlier, but we don't feel so in ours. And it appears to me that, if I understood Mr. Slay right, there are 9 points perhaps to be dealt with along with this. I don't see that it has to be denied.
I just pulled that number.
Several? Okay. Several. Okay. Say 9. 9 sounds good. Okay. You don't have to deny it on 9, 8, 7, 6, 5, 4, 3, but only one. We're asking you to deny it based on this. Thank you very much.
Thank you.
Mr. Busby, I thank you for your compassion. And I'm the same way. I'm compassionate about Rankin County myself because I've been living in Rankin County now for 30 years. I've got a business there in Avalon Center that I've been there since '98. And, you know, I sit on the committee on the overlay. Mr. Slay, and a question that I've got for you and the board is everything null and void? What we worked hard to do to get the overlay passed, is it not worth the paper it's written on?
I think this is because it was pre-overlay.
The overlay.
Okay, well, how about covenants don't mean anything?
They absolutely do among the landowners that are there.
Then we have, when I met with Dr. Ward in '97, he came to my office, sit there on the edge of the couch, and I negotiated purchase of the property of 2 lots there, and ended up buying 3 lots. And I got a set of covenants before I built. He went over everything that I had to do. I couldn't have a blacktop drive, I had to have a concrete drive. And I've honored the covenants that were set in place for that Avalon Center. So I'm asking you guys to reconsider that. You too, Jay. Because Rankin County is my home. I wore out a few pair of shoes, so it's home. I'm a Nashville, Tennessee, where I was born and raised, and I'm transplanted from Nashville, and I don't like country music. But anyway, thank you so much for your time.
Thank you.
Bless you.
I did want to just make it clear, though, that the covenant issue is not the determinative issue here. If this board were to assume that, or take the position that a majority of these people affected by this oppose it, that would be grounds for you to deny it, irrespective of the covenant.
Again, Brad Reeves.
Hang on, Brad.
Wait a minute.
We need to move through those who are speaking in opposition.
Oh, I thought he was going
Unless you fix to be in opposition. Good morning.
All the statistics and all the things that need to be said about all the facts have been said. I invest in real estate, and I checked the covenants, and I read the covenants before I went over there and bought a building. I bought one here originally in Tupelo, and I went back and bought a lot next door. I came back a year later, and I built a building because of those covenants. I knew the protection that would be there long term. Every time we've been investing in something, we try to look at it 15 years down the line. We look at the covenants. We look at what we're going to have when we get there 20 years from now. I'm going to be able to leave anything with anybody if I don't spend it all first. But I'll ask y'all to implore y'all to think about what we're trying to accomplish over there. It was mentioned here a minute ago that he was representing the small businessman and giving them an opportunity. The small businessman sits right behind that sign where it's going to be, and we don't want it. That's how firm I am on it. Thank you for your time.
If you would, for the record, we just need a name and
Metro
address.
Land Company. Metro Land Company. Ross Branding. Thank y'all very much.
Thank you, Mr. Branding.
Is there anyone else to speak in opposition? Anyone? Mr. President, it's the board's prerogative. Mr. Reeves has indicated that he'd like to have an opportunity to speak.
If it'll be short.
Well, thank y'all for your time. I'm certainly not up here. I don't want to rehash anything that's previously been said, but since I spoke before the hearing, if we want to call it that, I just want to speak about a few things. As far as the lawsuit, as was addressed and was my concern, you know, one of the main things we heard was about the covenants. We certainly respect the covenants. There's no dispute whatsoever that the covenants exist or that they should be followed. I would ask if you have a copy of the complaint in this lawsuit, and I would like to enter that into the record. The Exhibit C, there are multiple letters to Mr. Starling, these certified letters asking for any records or anything as far as the Architectural Review Board. And then Mr. Starling replied back saying, I don't have any records on any minutes or information of the elected officers. Again, there's another letter a week later, February 12th of 2015, asking for information. And finally, on March 27th, asking, you know, what do we need to do about these protective covenants? We'd like to address that. And so that's the main thing I just want to say. My client has not denied that. We've tried to appear before this board, not this board, I'm sorry, the Architectural Review Board, and say, how do we need to handle these covenants? And unfortunately, hadn't gotten a response. Have been certified letters. When we did, it was, we don't know anything about it. We don't have the records. We don't know who the elected officers are. The last thing I'll just say is the attorney representing my client, the decision should be made based, I know the feedback is important, but it is a legal issue, and this is, it's not necessarily legislative, but is a judicial decision. And what controls that is Section 2904, which addresses dimensional variances. And again, we're talking about this is not under the overlay district, but under the previous ordinance. And 2904.01 has three things that are to be considered for the variances. And if it meets those three things, then the variance should be granted. The first thing is that special conditions and circumstances exist which are peculiar to the land, structure, or building involved, which are not applicable to other land, structures, or buildings in the same district. And we would certainly talk about this is a unique situation where you have a commercial district, commercial subdivision right adjacent to residential subdivisions. And certainly when it was a 2-lane road and developed, I don't think anyone thought that this would be a 5-lane road. I respect Mr. Starling, but I would disagree and say there certainly has been a change in this area from a 2-lane road to a 5-lane road. So we do think there has been a change in the character of the neighborhood there. Second thing is that you have to show that literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by properties in the same district under the terms of this ordinance. Mr. Busby referenced that a variance was granted in 2008 for another LED billboard in this area. So we would say that others are enjoying that right. So we think that he and my client, let me say, is entitled to a variance. It's been done before by this board in the same area in 2008. And finally, that granting the variance requested would not confer on the applicant any special privileges denied by this ordinance to other land, structures, or buildings. Again, would go back to the other billboard in the area that's been approved. Variance was previously granted. I understand there's an overlay district, but since we fall under the previous ordinance, we do believe, and I think this would probably be the last billboard granted, but we do believe that we're entitled to a variance under this previous ordinance. So,
right.
Thank you for your time.
Thank you.
Mr. President, with your indulgence, I would ask, is there anyone else to speak either in favor of or in opposition?
Can I make one comment, please?
Okay. Yeah.
You know, there's been discussion about this being a changing landscape here. Avalon Center was conceived in I think 95. It's when Dr. Ward and I. That's 20 years. That's when all this established. And what we're concerned about, yes, the covenants is an issue, and we don't want to have to sue and put injunctions and all this stuff, but we will. But what we're concerned about is the safety and the ordinance. I mean, why should somebody get the ability to just say, I don't want to abide by this law. I don't want to stop at this stop sign. I don't want to stop at this red light. You guys have the laws. You've made this up well in advance. Just, that's all you got to do is just vote that no, we're disallowing this application, and then it's done with. I don't want to have to live with it another 3, 4, 5 years. That's my guys are tired of me coming around grabbing petitions. Every lot owner in Avalon Center has signed 3 petitions, 3, saying no to the billboard, saying no to the sign. What else do you need? Thanks.
That's enough. That's enough. I think the only thing, you know, going back to the fact that one was approved previously with same kind of
if I may,
questions.
Mr. President, if I may address that issue, I think it does bear some clarification, and I'm going to ask Renee to jump in if she hears me say something that is not accurate. With respect to the other billboard that was referred to, it's important that the board know that that board actually was located in its original location before the county adopted zoning. Okay? So it was not controlled by any sort of application that would have come before a Board of Supervisors.
Okay.
All right? So it was installed before 2004 in an original location along Old Fannin Road.
Okay.
It was later, and therefore, when zoning was adopted, it came into zoning by virtue of what's called a non-conforming use.
I see.
It can stay just where it is, just like it is, without any additional authorization. If there is an intent at some point to upgrade, enhance, change in a significant manner, do anything other than basically keep it maintained and repaired, then that requires an application to come before the board, and the board can then either approve or disapprove of the continued use of that land use under the existing zoning ordinance. We don't know how, when, or why, but apparently the owner of that original billboard that was non-conforming use decided of their own volition to move it, to electrify it, to improve it as a double stack, as I understand it. And they did that without any permission of any Board of Supervisors. It's very important for you to understand. You didn't grant anything. You didn't approve anything. You were not given an opportunity to even address the issue. Now that that has been brought to our attention, we intend to investigate that particular board. So I want to be clear with everybody here how that original billboard that was referred to came to be where it is and what it looks like. So the fact that it's, and I don't know this to be a fact, but the fact that it was represented to you that it's within a foot of a residential subdivision was not by virtue of any variance granted by this board or any other Board of Supervisors, right? The other clarifier that I want to bring is that there's been references to, and you've even had a presentation before you of some zoning ordinance language, which is appropriate under the circumstances, but I want to be clear about what we're here on. We're not here specifically on the zoning ordinance. We are here on your sign ordinance as it existed in 2012. That's an important distinction that you need to keep in mind, okay? So the issue of change in character and quality of neighborhoods is an important consideration, and it's one that you have the ability to address, but that is not reflected in your sign ordinance. The issue before you today is it appropriate for a billboard to be placed within 1,500 feet of residential subdivisions in violation of a setback requirement that is in the sign ordinance? Now, that is the fact that is before you, and that is a fact that is not in dispute. In fact, the applicant explained to you that is the one issue that they do not qualify in terms of placing a billboard there. That's why they're before you asking for a dimensional variance. Okay?
Mr. President, I'd like to make a motion.
Before you do that, Craig, Rodney, I'd like to make one statement. I think if memory serves me correctly, we've already turned down one request for a billboard in close proximity to where this request is made.
Yeah, yes or maybe, I don't know.
Oh, I'm fairly certain of it.
Okay.
Was it digital?
It was a different company, and they were gonna upgrade it or put it in the new digital billboard.
I think you're correct on
It was denied as
Right.
well.
And I got,
So this won't be the first one that's been denied based on the facts before us.
right, and I got to ask a question on this. Ms. Renee, from memory, if that doesn't serve me well, how many different subdivisions would this affect as far as 1,500 feet setback?
6.
6 of them?
Yes, sir.
Not just one, but 6 subdivisions. Okay.
I'm sorry, Mr. Keith, go ahead with your motion.
Mr. President, I'd like to make a motion. It's lengthy. It's lengthy.
Do we need to close the public hearing at all?
Yes, sir.
before
If there's no other information that's required by the board, it would be appropriate to close the public hearing. Mr. President, do you see any
Yes,
reason not to close it?
No.
All right, this time we will
Been here
close
long
that
enough.
public hearing.
Okay.
We're closing it. Mr. Keith,
Just
are
a
you agreeing to withhold your motion until we can get the public hearing closed?
Shut it down.
Okay, thank you. All right, we're going to close that public hearing. At this time, it'd be appropriate to take action.
Okay. Do I have a motion?
I'd like to make a motion.
Okay.
Even though there is a pending lawsuit between the applicant and the Avalon Center Property Owners Association, I move to deny the requested application for variance to place a billboard on lot number 2, Avalon Center, on the following grounds. There's 5 grounds. The proposed site of the billboard is closer than 15 feet from 6 different residential subdivisions in the area, and the language of the county's sign ordinance that applies to this request prohibits placement of a billboard closer than 1,500 feet from the nearest subdivision, and the applicant has not made a sufficient legal or factual showing that it is entitled to a variance from this 1,500-foot setback requirement. The purpose of the 1,500-foot setback for billboards located near subdivisions is obvious. Residential areas deserve special protection from intrusive and distinctly commercial land uses, of which a billboard is one. Billboards are not proper land uses within or near residences. It is important that there is a significant separation between intrusive commercial land uses and residential neighborhoods. Number 2, the applicant's proposed use as a digital billboard is not a use that is in keeping with the general character of surrounding properties being primarily residential in nature. Number 3, sufficient special conditions or circumstances do not exist which are peculiar to the subject property, nor to the proposed use, which are not applicable to similarly situated properties in the same zoning classification. Number 4, the literal interpretation of the county zoning ordinance does not deprive the applicant of rights commonly enjoyed by other properties in the same zoning classification. And number 5, if granted, the variance requested would confer on the applicant special privileges that are not available to other property owners located in the same zoning classification. Period.
Okay, I can't repeat that.
Well, you could.
Okay.
I second that motion.
We have a motion from Mr. Keith. Second, Mr. Wilcox. All in favor say aye.
Hang on, hang on.
Wait,
Get a little
discussion. Let's have
Yeah.
some discussion. Okay.
I just want to ask one question, and this really isn't pertaining to this matter. There's 2 other billboards located on the other end that are already existing, and I know they're going to fall under our current overlay. So when they come before us wanting to turn those digital, will they be able to do that?
It'll be the prerogative of the board to address the issue of a non-conforming use, because it will be non-conforming at that point since it's within the RCD.
Yeah.
You'll have the ability to address that request when it comes before you at the time, Jay.
Okay. All right.
Okay, any more discussion? All in favor?
Aye.
All opposed?
Nay.
And I would like to say I'm nay based on the fact of what I said earlier. I just think it was fair to have all the facts, even after, with it may be in the court, although I think the outcome probably would have been the same, but I think it would have been fair to have waited till we had everything. So that's why I'm voting nay. Okay.
Mr. President, with your permission, obviously the motion as stated into the record, and which is a part of the minutes, it is reduced to writing, and we'll make that a part of the official minutes. If anyone wants a copy of the actual motion itself, we have extra copies.
And just to be official, it's dead, done, not coming back up.
No, sir. The reality is that the applicant, on the basis of the denial of the board, has the same exact ability to appeal this board's decision just like it did previously in 2012.
Okay.
And hopefully with better minutes. More information to the court.
I think the minutes will be clear.
Thank you.
Okay.
I'm just hoping it gets up there.
Ms. Laura.
I appreciate that.
All right, man. Be good. Thank y'all.
Y'all have a good day.
Y'all have a blessed day.
Three nays.
So, can you make this a little snappy? I got a couple people waiting.
Yes. Gentlemen, the first item I have under my section this morning is a presentation by JH&H Architects on the Chancery and Justice Courthouses. Carl Franco and Jeff McGee are here to make that presentation to you.
All right.
Okay.
Did you bring some schematics with you? Some schemes? Okay.
He's got a...
All right.
Okay. Could we have a quick recess? I think we might need one. Yeah.
I would like to recess.
Yeah, you want to recess?
I gotta go back again.
Okay.
Again.
Yeah, Bridget's, will you just need to scoot down? I didn't get that.
You got a computer? Yeah.
Craig.
Just shoot me.
Oh, well, that was a different kind.
Yeah, it's saying computer signal is coming up. We got a signal, does it work? Yeah, but that's because his computer hasn't come on.
I didn't know that for sure.
It's not supposed to be.
John said
It's supposed to be on red.
I got it on red.
Okay.
I think I did. I just need to look, but I'm pretty sure. That's what he's doing.
No, he said. That's what Freddie said.
That's okay. It's all right. It's not material.
Ours is not nearly as interesting as some of the things y'all go through.
Yeah, it seems like we kind of made it for them in here.
The one 2 weeks ago was twice as long.
Yeah, it would not quit. Oh yeah, it was 12. It was after 12. We got out here. 120 is that what it was? It was long. Either Lamar or Eric Exum.
At least it clears out everybody when it goes on like that. Everybody's ready to go. Hey, really, they don't have the fuel tank. Hey, you're so
the only person that said that was she said years ago when I went I saw her. She thought that
that may be good.
Yeah. She mainly answered questions. She wasn't for it.
I'm sure.
I think she knew what to do. I told her, we was doing the building. She said, what's going to make more traffic? I go by this one here, like she and Clark's yeah. I never seen 2 cars. So I told her, I said, no, don't worry about no light. Why y'all building? Just make sure you take that line along the cross. Yes, just right there. Yeah. Straight across. And she's the only one that said anything. Nobody else came in. Yeah. Just to get your contract stuff together, and then we'll get your permit issued. Thank you.
You did. I sometimes here.
All right, we still got enough. We got enough here. Let's move on. Oh, Jay, hurry up. Let me go see if I can get them out. So your kids home? Graduating?
No.
7th year?
1 year, first year, we passed everything to.
Mr. Wilcox. What are you talking about?
I guess my guys, I was gonna do it at the end.
I'll get it out there.
I'm going to, I guess I'll get. I'm sorry, Brett's still gonna be.
We'll go ahead. Rock and roll. I don't know where Walter is. He had to talk to somebody. No, Jay's busy. All right, we'll go ahead. I'll just check. Okay. Okay, let's move on here. Good morning.
Good morning. We'll try and keep ours short so they don't get out here before lunch. But
You got to get on stick.
ask any questions you want. And just as a recap, we were here a few weeks ago and presented our initial concepts for the new Justice Chancery Court Facility Complex. And at that time, the board instructed us to go back and review this with the users and stakeholders. And so we have done that with all the groups, which included the justice judges, their clerks, the county prosecutor, the chancery judges and their staff, the chancery clerk, and the sheriff. So based on their input and comments, we have revised the preliminary design concepts. And one thing I want to emphasize again here today, these are still very preliminary and conceptual, but we have included everyone's comments, or tried to, so we've incorporated into those. As we go forward, if the board so chooses, we will continue to refine these plans and get them down to the point to where they can be constructed, if that's the board's wishes. We also will be going back to the users, the same ones I just mentioned, and the stakeholders, for further comment as we get further into this to get the technical details. So what we're going to present you here today is we've narrowed this down. In our last meeting we had 4 concepts. We have narrowed this down to 2 basic concepts, which are very similar, and I'm going to run through those quickly today, but please stop me at any point and ask questions, or we can recap. What you see here is what we call Scheme 1. It was the same as Scheme 1 before. So we will go through what's changed on that, but one thing right off the bat on the site plan, we've changed the parking. We originally had them at 10-foot spaces. We've reduced that down to 9. We have confirmed that with the city of Brandon. That does meet their ordinance requirements. So what we've done is now we've got a total of 175 parking places. Before, we only had 136. So that's a pretty good increase in parking places. We're still showing up to the right-hand corner the possibility, if that ever becomes county property, to add some more. But other than that, the basic plan, site plan for Scheme 1 remains the same, except we've increased the sally port and added another sally port, which I'll explain a little bit later. The bottom floor, if you remember correctly, this is a multi-level site, so we've got bottom floor. We have one central entry into here, a couple of changes we've made just to point out to you, and these are mainly based on the sheriff's comments. We've added some gun lockers, regardless of what Jeff says. We put them where you desire. Just want to point that fact out. And you know, this is real important. You come in the doors and you need some gun lockers that are sized for where ladies could put their purses and whatever. And then you would go through the metal detectors. And we have one central security checkpoint, and there'll probably be two sheriff's deputies here that would control this. So no matter what you're doing in this building, to get into this building, you're going to go through metal detectors. You still have 2 sets of elevators and stairs to go up to the different points. We did add a restroom for the security checkpoint station, so that, you know, that's going to be critical. You got to have that so that they don't have to leave their post. But as we talked about earlier, one of the main issues in this design is to improve security and provide that. The basic plan is similar as before. You have the Chancery Clerk on the main level, the Chancery Clerk and the Justice Court. On the other side, you still have basically a Chancery function and a Justice function here. Going to the Chancery Clerk's area on the first level, we have made some, mainly in this area, all we did was switch some spaces around based on comments from the Chancery Clerk and some functional needs. So you still come in the elevator, you come into public restrooms, you have a waiting, you come into the central area, work area for court records, land records, court records. This is the court records area here. This is land record areas here. Now we have discussed with them how much can we reduce this space, or, you know, since everything's being scanned electronically, and essentially the comments we got back to them, we don't have to increase the spaces, but we have to maintain the same size. They are scanning everything, but they need to maintain their hard copy records at this point. So we will continue as we move forward to look at how to make this any more efficient. One thing you will notice, though, we did add a sally port in this area at the request of the sheriff for the Chancery court. And Jay's not here, but he will notice we've also got rid of an elevator and the stairs that was right here. So we did maintain the secure elevators and stairs, so we added a sally port here. This is a secure corridor that they could bring prisoners in and go up the secure stair or the secure elevator to the second floor. In the Justice Court side, we made several changes there. As you come in, you have a lobby area right here. You come up the elevator, you have a lobby area. This is still similar into the Justice Clerk Suite. We did rearrange the evidence room, made it a little bit larger, and the copy room, and this was a request from the Justice Clerks. As you go through that suite, it's the same relationship basically to the Justice Court. One thing we did do is this was the original area for record storage, and we kind of flip-flopped that. You still have the back of the house. All this area back of the house is secure, and you still have basically similar to what we had before, the justices' offices and their chambers. You have a large justice courtroom capable of seating 175 with a jury box. That does have access directly to the jury room, which we did rearrange to combine some spaces. It's now a jury deliberation court, the judge's workroom conference area. So that we made that larger to accommodate both their spaces, but we were able to get rid of another space. It has access to the toilet facilities and things of that nature. One of the major changes we did, there were some comments about security. We expanded the Sally Court because they need a space for 2 vans, not just one. In our original design, we only had 1. So you have a secure Sally Court. You come down through the secure corridor, and I think the sheriff had a great suggestion. We rearranged these holding cells. You have the male holding cell here and the female holding cell there, and we added a security room to be manned that has glass on all sides so they can have clear sight line into those areas. And another thing we did, which I think will work well, we haven't bounced it back, but we have a secure inmate testifying space. So in other words, they can walk the prisoner in here, put him in here. It has glass that the judges could see, but he never has to get in the courtroom. Now he does still, if judges want to bring him into the courtroom, they still have the capability to do that. But if the desire is to, again, maintain a higher level of security, he can testify from this space and never has to get in the courtroom. And I believe they're using this process at Richland in their court facility. So we've tried to even upgrade the security we had with this corridor so that he does not have to get into that courtroom. We have a smaller courtroom capable of seating 75, so that's pretty much remained the same. We did rearrange the prosecutor suite a little bit based on comments we got from the county prosecutor in those spaces, but one of his main concerns was that they don't want to have just complete open access to the public, but he did want to have more access than them having to wander down through the corridor to get to them. So we created a separate public entrance that would be secured. You come into the reception and she would direct them to wherever they go. And again, I don't think any of these plans have been, since we made the revisions, have gone back to the users for their comments, but they will at some point. Going up to the upper floor, you come up the elevator, and this is the Chancery Court area. This remains pretty much the same. We did increase the seating area here. There will be low walls or walls of glass in between them. This is based, again, on some comments we got. You still have a secure area right here. We rearranged the holding cells, moving down this end, because as they come in from below up this secure stair elevator, then they'll come right here. There'll be a security, and there'll be some holding cells right there. The rest of it remained the same, with this one exception. There was a request to increase one of the Chancery courtrooms in size, because they have some hearings, like annex hearings, that they can have up to 100 people. I'm not sure that's going to seat quite that many, but somewhere between 80 and 90. And we didn't really add, we added a little square footage, but this now sits above the new Sally Port that was requested. So in other words, it's not, there's the Sally Port below, this just sits right on top of it. So we had to add the Sally Port, so we're not adding that much here. In total, though, we have added about 12 to 1,300 square feet in this scheme based on comments we got. Now again, if you decide to move forward, we will continue to look at refining this and squeezing this down a little bit, but I think this does, based on the comments and input we've got, this does work better than what we had before. One other thing we did add some more public restrooms so that people in these courts don't have to come all the way back down here, and we probably needed that to meet the code numbers anyhow. That's Scheme 1. Scheme 2 is similar to what Scheme 2 was before. we actually picked up 182 spaces. I mean, we've got 182 spaces in here, whereas before we only had 33. So we picked up, where's my cheat sheet, my math, 49 spaces from last time. So again, some of the reasons were because we went from 10 foot to 9 foot, and some of them we just rearranged some things on the site to be as efficient as we could. Again, this was the original sally port. We widened it. We added the other sally port into this area, and that's one of the advantages that this scheme too gives us. In this courtyard, we were able to sneak that sally port right in that space, and then we added some public spaces, parking spaces in here. So we have a total of 127 public and 55 secured spaces. And we've absolutely got this site pretty much loaded down as much as we can with parking. And as we move forward, one of the things that we'll have to do in working with Buster is looking at the grading on this site. And you know, we've got to maintain drives and certain slopes for handicapped accessibility. So, but we were able to secure a larger number of parking spaces. Going, the lobby is very similar to the other lobby. We did add, you can see the same gun lockers in the security checkpoint wayfinding. And you can see in the land records area, well, I may need a new operator. I'm overpaying, I think.
That's good.
The Chancery Clerk, again, is somewhat similar, but what you'll notice here, you come back in, we've got public restrooms. This is where the sally port, this is the main difference in this one. We've added the sally port in here. Again, it's secure stairs and secure elevator that will go up to the holding cells. What you see here in the other scheme, this is where the sally port was, and you see that we left this as it was. This provides a secure entry there. We did eliminate this stair and elevator, but we had to add it back over here, so we didn't gain that in this scheme. But what we have gained, I think, and you'll see, is more flexibility and even a higher degree of security in scheme 2. Justice Court, I think it's almost identical to scheme 1, except we flip-flopped some of the spaces in here, and you have direct access into the circuit justice clerk area. This is actually a better, more functional scheme, higher visibility. People come in, they go straight into this area. It actually works a little better. It provides some exterior windows that the other scheme does not allow us to do. It provides a little more efficient circulation between the justice clerk's office and the courtrooms. It still has, we did do the same thing about consolidating the jury deliberation in the judge's conference room and making these additional improved security requirements with the holding cells and increasing the, rearranging the prosecutor's office. Other than that, it's the same as scheme 1. Going upstairs to the Chancery Courts, what you'll see here is this is a secure stairway and elevator leading below from the sally port, and you've got the holding cells right directly across from them. And then this little security area doubles as an overview of this waiting area, and also can keep control, line of sight on the holding cells right there. In this scheme, we again increase the size of one courtroom, but instead of this one on scheme 1, it's this one on scheme 2, because again, what we're trying to take advantage of is just going right on top of that sally port that was added here, so we don't create an additional 2-story space. Everything else is similar. You see everything in the blue is still secure. We did add these 2 restrooms like we did on the other scheme. So, and this wound up increasing about the same, about 1,300 square feet or so. But I even believe that scheme 2 is even a higher degree of level security than scheme 1, and has some flexibility for future additions here. So, just briefly, the elevations right now, we didn't really get back and look at those. They're still the same. They'll still need some refinement. But we had very positive comments from everybody that reviewed these. We had very positive comments regarding the schemes, except for the comments that we gave you. The consensus seemed to be, and correct me if I'm wrong, Craig and Laura, because y'all were in those meetings, the preference seemed to be from the users on scheme 2 for a couple of reasons. the level of security, and then there was some flexibility with that courtyard. We need to add some few offices. We had a space already built in there to do that, because if you remember the site plans, there's really no more room on these sites.
Right.
I mean, without losing. So that seemed to be the consensus.
Scheme 2, we're still going to be utilizing the same number of officers, right? It's not going to require any more deputies.
I would think it should, because we've
Okay.
got still that one central check-in point.
Will it be additional construction costs by putting that courtyard in?
Not really, Jay. I mean, to be honest, you've got an exterior wall there, which is some cost, but on this scale of a project, it really won't be. It really won't. They're both going to be about the same. There will be, from the figure, the construction cost figures are going to be very similar to what we told you last time.
Yeah.
There will be a little bit of increase on both schemes because we added a sally port, but that does not have to be fully enclosed. We can use security fencing. In other words, all four sides don't have to be brick and masonry. They can be it can be security fencing. That was my understanding. Is that correct, Sheriff, in the sally port?
Did we not have one to start with?
We had one. We've added a second one.
Oh.
Yeah. So that
Size of the justice court. We don't care a whole lot of inmates in justice court. We don't care a whole lot of changes we do. They're going to be most of the time mental illness type thing.
I got you. Okay.
The holding cells for the chancery are handled 2 or 3, as opposed to the justice can handle up to 10. But it is better because what we've done before with only the one, we had to figure out a way to get them through the building. And here they come directly up the secure stairs and put them in the holding cells. So there should be very little interaction, if any, with the public. And that was the goal in all of this, and or with the staff. So, but at this conceptual stage, I would say the costs are essentially the same as what we alluded to before in that range. And if you choose to move forward, we will continually update that, because we'll have more accurate drawings and more accurate figures. And what we will do is we'll get a cost estimator involved from one who, that's not what they do for a living, instead of just using our numbers. And so we'll be able to use our numbers and compare them to theirs to make sure we're still working along the same lines of cost. So I guess we're here today having narrowed these down to 2 schemes. We've met with the stakeholders and users. We've incorporated their comments at the preliminary stage. So we're here to really present them to you for a decision, I guess, whether to move forward, and if so, with what scheme. If the board so chooses to do that, just to kind of tell you where we would go from here, we would begin with the next phase, which is design development. That would take these drawings, these conceptual designs, and start putting them into refinement and more. We would start bringing in engineers to talk about mechanical, structural, electrical requirements. The first thing that would be done if the board chooses to move forward is we need to get authorization to do geotech or soil borings on the site. I say the first thing. That's actually the second thing. The first thing is to acquire the property from Trustmark. I'm going to let Mr. Slay handle that. But just trying to tell you where we would go if you choose to move forward. We acquire the property, do the soil borings, geotech, and then we would move forward developing the drawings. And there would be several stages in that. Design development is what we call the next stage. At the end of that, we would have more defined cost estimates. We would have outline specs. We would then come before the board at the end of that phase for your review and approval. If the board chose to move forward, then we would move into the final construction drawings and bid documents. And again, we go through that whole same process, meet back with the users, refine the cost estimates, and then come before the board at the end of that stage with cost estimates and requests for bids. If the board chooses to do that, then we would take bids. That takes about 30 days, take another 2 weeks to approve bids, and then issue construction. And construction is somewhere between 16 to 20 months.
Well, should we go ahead and choose scheme 2 before you meet with all the attorneys to, or would that be kind of us, turning our nose up at them? I don't want to be seen as doing that.
My preference would
not my preference, my suggestion would be.
Oh, come on in there, Craig.
Do not quote me on that. My suggestion would be, Jay, that the board's been pretty clear about who ought to really be included in the process of discussion. I would suggest to you that that as frequent users of the facility, the lawyers, of whom I am one, I'll remind everyone, would not necessarily have much to add in the way of the significant number of spaces that you're looking at. Generally speaking, the common areas and the courtrooms are going to be the domain of the lawyers. I don't know what they can add about the feasibility and the utility of spaces that address judges' chambers and justice court clerk and chancery court land records, although there's some impact on the lawyers as it relates to land records. But the vast majority of the spaces are not spaces that the lawyers are going to have much in the way of input on. It seems to me that delaying action on choosing a scheme is unnecessary, simply to delay it to show it to the lawyers. My preference would be that if the board's ready to move forward today and choose a scheme, then the focus of the meeting with the lawyers would be on that scheme, as opposed to having to discuss multiple schemes.
I would envision, when we've done this type of thing in the past, I would envision their comments as refining some of the interior spaces and maybe even deleting some. We may have too many witness or attorney spaces in there is what I would envision. I would envision them being minor alterations that would help function better. I mean, we're not, obviously we've got a budget to work in. We're not going to be adding another 20,000 square feet or doing that. Would be mine. That's typically what, and we kind of do that as a caveat up front. We want their input because I think it's going to make the building function better, but it may be that we can save some spaces or multi-use some spaces. And that's what came out of some of our meetings. We were able to get rid of some spaces and multi-use of spaces, and then as we go forward, we will try and continue to do that, refine that so that we're not having any wasted space.
I got just a question. When you come up, when you go in here, as soon as you walk in, you see the restrooms, and then where you pay your fines and all are behind.
On the justice?
Yeah, justice.
Yeah.
Well, it's really on both of them.
Yeah.
Would that not create people wandering around more trying to find where to pay their fine?
Well, I think we need to look at that, Jared, and open that up a little bit more. We were so intent on trying to be efficient with space, and actually I failed to mention one thing we did do is increase the size of these restrooms. We can look at moving them away. Actually, we can open this whole area up. We can put the restrooms, somewhere in here, but it just adds some square footage. But I'm not.
Yeah, I was just thinking from a safety, security-wise. I mean, I know if you see people wandering around, say, "Oh, well, I'm looking for where to pay the fine," but
well, I'll tell you what
that's going to be identified.
I'll tell you what we can do, and that's again, I misspoke because one thing this scheme does do, we can take these restrooms and maybe relocate them in here and open this whole area up.
So I thought it'd be good if you walked up and you saw, boom, right here's where I pay my fine.
We can do that.
You moving around.
We can take both these restroom blocks,
right,
and relocate them in here, and this can become all glass, and people come up and it's clear then.
Yeah.
Or one or two, or whatever we need to do, and that's not. Again, that will add a little bit of square footage, but in the scheme of things, those are the kind of things that we need to do long term, because we're not talking about tons of money here.
And I was just thinking that would make them more, our people that work in those departments, they're right there seeing.
We can actually
get back in a corner back here.
Right, we can actually take these set of restrooms and these sets, and we can make a block here that be multi-use. I guess we're trying to get into this keeping things as separate as possible, but we can study that.
Well, the ones over on the left at Chancery, they're not quite as bad because you're not looking to pay where you pay your fine.
Right. So,
but anyway, that was just a thought.
Well, that's a good comment, and I think it's a worthy comment, and I just, and that's one reason we go through this process. Mm-hmm. We get focused, and then really, 2 weeks short of time period sounds like a lot, but when you're working with a building this complex and this large, every time we do one thing, it affects about 15 others.
Right.
And that's why I'm not doing it. That's why I got Dane, the young people doing it, because I can't operate that computer like they can.
So we didn't really take out an elevator, did we? We just kind of moved them around.
We moved it. We started taking one out, and then we had to add it back in.
You were out of the room.
We took it out.
You added it back in.
Yeah.
That's right.
Yeah.
I took it out because I knew, but I had to put it back in. And
Jay, we only take it out when you leave the room.
I see that. Yeah. I got it. I got it.
I tried.
Y'all determined to have that extra elevator in there.
I'm still looking. If we can put a slide or something in, we'll do that.
Just label it something else.
Well,
Jay's space.
I'm hoping I don't go up there.
I hope you don't go up there either.
Yeah.
Hope neither one of us
I
wind
can't
up in that
afford
elevator.
another divorce.
Well, I'm not going to comment. Again, there's still a lot of refinement that has to go in these plans, and we would start blowing up each space and sitting down with individual user groups to refine that. We did hear comments like, all these courtrooms need to have the, latest technology and audio visual, and we understand that.
What's the little blocks for?
These are just color codes. These?
No, at the top left.
Oh, this is an overhang. So there's a security fencing in there. That's just support. That's an architectural thing that we got to look at.
Oh, so that's to make it look good, in other words.
Well, you gotta have some support to support that, but they don't necessarily have to be that big. But that was an outdoor area that we were trying to make look good on that end of the building.
I got you. Okay. All right. Oh, I see. So y'all don't care about Justice Court over here. Y'all just worry about chances.
We've got one here. We got this end of it too. But see, this is the secure access for the Chancery Court people to come in this way. So
I'm just asking: is that courtyard? I mean, is it more? What would it be used for other than?
Man, it don't matter. It don't matter.
Well, is it not a security thing?
We got a gate on it, and what may happen, Jared, it actually may turn into less of a people courtyard to a mechanical equipment area. But it will be secure. It will have a gate on it. It won't be open to the public.
I don't think that's what I was thinking to say. I don't know, security-wise, I wouldn't think we'd want something there.
No.
I think one other big issue with the courtyard is that it opens up outside.
Opportunity to smoke.
Outside light.
Yeah, and it allows us to get like some windows and some offices.
Okay.
And it does provide some flexibility if we want to rearrange, like for instance, moving this back. If we were to relocate the restrooms, the courtyard space itself is going to be fairly small. Mm-hmm. But I do agree, the security, we didn't ever intend it to be open to the public at all.
Okay. Okay.
Looks good.
What's next?
We ready to make a move?
Y'all have any other questions?
Okay.
Mr. President, that will conclude the presentation. If the board is of a mind to go ahead and make a decision, I would suggest that we would add that item to the agenda, and then if the board is ready to make a decision, go ahead and make a decision.
Well, nothing is. We can do that without any of these possible changes.
Yes, sir. What you're being asked to do today is to select a scheme so that the architects can proceed,
right,
and some other activity can proceed, and get the clock sort of moving on that work product. You're looking at a 6-month process from the date of the decision on the scheme. So we're just simply trying to tie down which is the scheme that the architects need to focus on and refine.
Was it number 3?
No, sir.
No.
No,
just
sir.
checking. All right, I make a motion to add this item to the agenda.
Second.
Motion made to add this item to the agenda by Mr. Bishop, second Mr. Wilcox. Any more discussion? All in favor say aye.
Aye.
All opposed?
I make a motion to choose scheme number 2.
Second.
All right, motion to choose scheme number 2 by Mr. Bishop, second Mr. Keith. Any discussion? All in favor say aye.
Aye.
All opposed?
Mr. President, and I'm jumping
And all
into...
this is pending whether we have property to build it on.
Yeah,
Thank you
I was
for
gonna ask you,
bringing that
any
up.
update on that?
Yeah.
You okay, Ms. Laura? I'm jumping into Ms. Laura's section of the agenda here. And I hope my comments are taken at face value, and if I express some level of frustration, it's not intended to be unnecessary frustration, let me put it that way.
I've always taken them at face value.
The issue that we're presented with is this. We have a roughly 8 to 9 acre piece of property that we have been referring to as the Trustmark site for well over a year. We've had a primary focus on that site as the most optimum site to locate our new facilities for Justice Court and Chancery Court, primarily because the county owns the vast majority of that site. All but about 3/4 of an acre of it is controlled by the county. There's a portion of it, roughly 3/4 of an acre, that is owned by Trustmark Bank. Very early in the process, your former county administrator approached Trustmark, their local representatives, and engaged them about that site and the county's need for that site for the facilities. And the reception was favorable. We've reported to you consistently, your staff has reported to you consistently that the response from Trustmark has been favorable, that they desire to accommodate the county. They are concerned, were and are concerned about the impact of their operations that turning that piece of property over to the county would have. They use that for employee parking, and so there was the issue of how do we address accommodating Trustmark for giving up employee parking space to allow us to move forward. There's a timing issue that's involved there. If we get access to the site, we are engaging in a process that's 2 to 3 years before we have a completed site. And until we have a completed site, we can't move existing personnel, facilities, and functions into that site. That makes sense. And so the workout for the parking issue has been, and this is all conceptual and planned, no firm decisions, but the workout has been that we can take an existing facility and raise that facility and convert that into parking space that could then be used as Trustmark's alternate site. There would be about a 2 to 3 year period where Trustmark's employees would have to find other places to park, or they would have to provide space for them to park somewhere else. And it may be inconvenient for their folks for some time. So that has sort of been the hitch in the get-along. We've consistently, I think it would be appropriate for me to say that we have hounded Trustmark unmercifully to get a decision about transferring that property to the county. They tell me that they are in the process of evaluating the request and trying to come up with some sort of proposed solution. We don't have anything from Trustmark as I stand here right now. We're continuing to wait. I have explained the timeline. I have explained the time crunch. And while I think that the local folks are really doing everything they can, there are other decision makers involved in the process, and they're taking their time to get us an answer.
I think you're exactly right, because I spoke to someone this morning, basically said the same thing. I said, we've really kind of getting against the wall here. We need to know, otherwise we're going to have to punt and start over. So we really need to know. And their reply was, I'm passing that on, putting pressure, but basically higher up.
I have anticipated all along that this was going to get worked out. I still feel that way. I'm hoping against hope that we'll have an answer.
We are now 100% officially waiting on them.
That's correct.
Right. We've done everything we can do.
And with that, I would like to discuss with you something that we've engaged architects and your consulting engineer about, and that is the soil borings, the geotech that was referred to, which is the absolute next step in the process after we secure the site. Geotech is not a lengthy process, but there is some timing issues. You got to get that scheduled. That has to be done by some local geotech guys that our consulting engineer typically uses. And so the suggestion is that is not a terribly expensive process, and it's something that we can go ahead, if the board is of a mind to do so, go ahead and authorize to be done and get the soil borings done.
On their property?
Is it the county's property?
How can I
that.
nuance this? Yeah.
Okay.
Yep.
Yeah, but, you know, really, how can we move forward anything if we don't know, we don't have a footprint to put it on?
And we discussed that, and the issue was, you know, how comfortable do we feel that we're going to get this worked out? The reality is, Mr. President, that if Trustmark comes back and says, thanks, but no thanks, or, you know, we got to work something else out with y'all, and there's a continuing delay, the alternatives for the board at that point are minimum. But one option could be to reduce the size and footprint of the facility, separate the facilities, something like that, and continue to look at the Trustmark site, the part that we own outright, continue to look at that as a potential location for some sort of facility. I think the geotech could be used for purposes that benefit the county.
It may be, but, you know, well, now that we've adopted Plan 2 and we're ready, that's just sending a signal that, you know, they got to have our property.
They already know that.
Well, I know, but I mean, they're still not coming forth. It's not hard to do anything if you don't have something to build it on.
Well, I guess we start going out there punching holes in their property. You might think we just gonna do it without their permission.
Have y'all considered my suggestion to put it in Pisgah?
And what?
In Pisgah.
Oh.
Noted.
They don't have a trust mark up there.
So
maybe the flavor of the board is just, let's get an answer for Trustmark, and then we'll deal with the
No, I'm
geotech
fine with
request.
going and doing it, but I just don't want to vote on it.
No, I think we got to know.
Well,
we've approved a design, but I don't really see how we can go any further until we have for sure
title
property. Yes, I mean, I want to build my house over here. I haven't bought the property yet, though.
I don't want to put your consulting engineer in a box. I mean, it is something that's going to require authorization.
Right.
But
well,
again, you didn't.
Where does that put us?
Well, you didn't answer the
I
whole
can't believe
question.
our attorney is asking us to do this.
You didn't ask us answer the whole question. Are we going to just do it on county land, or are we going to also go onto their property?
We would ask for permission to do the geotech.
Greg, you can do it like this. It's going to be that directional
okay.
board.
Oh, the directional
Shoot it over here.
So
Yeah.
we
We'll
need to
start
add
on
this to the
county
agenda.
property.
Yes, sir.
All right, I make the motion to add the geotechnical work to the agenda.
All right.
Second.
Motion, Mr. Bishop, second, Mr. Wilcox, add this to the agenda.
No, on a question.
Any discussion?
Yes. Now.
Yeah.
We're gonna get permission.
We are.
Yeah.
Okay. Well, that's what I was going to ask. What if we don't get the permission?
We won't do geotech on that.
Okay.
On
well,
that
that'd
area.
be-
We'll do it everywhere else. We'll have those borings done.
Yeah, 'cause I don't want to get off over there.
The rough estimate on the cost of the geotech is in the $10,000 neighborhood.
Okay.
But I don't want us, if they're not going to let us do both, why would we do one, spend $10,000 and then go, whoops, we can't do
All
this?
you're doing is authorizing us to proceed. If Trustmark comes back and says, we don't want y'all on our site doing the geotech, then the engineer and I'll get together and decide whether we want to move forward.
Okay.
The authorization will be there. We're not going to spend the money unless we
All
got
right.
Trustmark.
We're not going to even drill on ours until they have.
If that's what the board desires, that's the way we'll handle it.
I think that's the way we need to do it myself.
You okay with that? Okay. Jade,
Okay.
are you okay with modifying your motion to allow or authorize the geotech with Trustmark's permission?
I guess.
And
Well, their permission, though, is also gonna have to mean they've agreed to let us have the property.
No, sir.
Not necessarily.
Just getting permission through the geotech on their site, just getting onto their site is all we're really looking for. I don't know that we can, I don't know that we'll get any further, Jared, if we tell them, not only do we need to know if you'll sell the site, we need your permission to get on it to do geotech. We're not gonna get any further than we have. Yeah.
Oh, gosh. I think just Hal Williams saying okay is fine.
I think that's, you know, a phone call saying, yeah, that'll be all right, will satisfy me.
Just him breathing hard is good enough.
I'll second Jay's
We'll get
motion.
Rodney over there with that microphone.
I'll second Jay's motion.
Okay.
That was my vote.
Okay, motion by Mr. Bishop. Second, Mr. Wilcox. Any more discussion? Okay.
This is just to add it to the agenda.
It's just to add.
All in favor, say aye.
Aye.
Aye. Everyone says added.
Yeah. I make motion to approve moving forward with geotechnical services.
All right, motion approved, Mr. Bishop. Second,
Second.
Mr. Wilcox. All right, any discussion? All in favor, say aye.
Aye.
Anything else?
All opposed?
Any nays?
Nay. I just don't believe in getting the cart before the horse. I mean, you know.
I'm kind of agree with you, but, you know.
Well, make up your mind.
This might.
Well, as long as they say that they're not gonna,
anyway.
you're not gonna drill any holes or anything else unless they say you can get on their land. All right.
Right.
What's next?
That's right.
We have one more item, don't we?
Okay.
And I have two more to add, but I promise I'll be very quick with them. The next item I have is approval of additional Liebert HVAC system to be installed by Richland Air Conditioning Service Company for the computer server room and the UPS room at the Juvenile Detention Center. You know, this is what Johnny came before, and we've taken quotes on it, and Richland was the cheapest, and it's $24,005.
Motion approved.
Second.
Motion approved, Mr. Bishop. Second, Mr. Johnson. Any discussion? All in favor, say aye.
Aye.
All opposed?
Okay, I have two items that I need to add. The first one would be approval to allow Delta Software to develop a program for Justice Court for their electronic transfer to AOC. House Bill 585 makes them have to report their criminal cases, and it's on a certain Excel spreadsheet, and they're going to design that something that will import it to keep Jessica from having to do double data entry. They've given a quote of around 800, I believe, 875 or somewhere in that neighborhood to do this. The second thing that we need to add is first responder refresher class for Leesburg. It'll be 10 men. It is in the budget, and it'll be approval for school next week at Hines Community College.
Motion to add these items to the agenda.
Second.
Okay, motion to add these items to the agenda by Mr. Wilcox. Second, Mr. Bishop. Any discussion? All in favor, say aye.
Aye.
All opposed?
Okay, the first one is the approval to let Delta Computers program a system for the electronic transfer to AOC for Justice Court.
So is there going to be a recurring cost on that?
No,
Okay.
that'll just be to develop the program so they can do that each time
Motion
they need
approved.
to.
Second.
Okay, motion approved by Mr. Bishop. Second, Mr. Keith. Any discussion? All in favor, say aye.
Aye.
All opposed?
Okay, and the next one will be the first responder refresher class for Leesburg for next week.
Motion to approve.
Second.
Motion approved, Mr. Johnson. Second, Mr. Wilcox. Any discussion? All in favor, say aye.
Aye.
All opposed?
That's all I have.
Okay.
Can I go home now?
Executive session? That was additional business you just added, correct? No?
Right, that was additional business.
Okay, we have additional business.
Yeah, I've got one thing. This is real easy, I promise you, real quick.
Okay.
Just found out possibly that could be from House Bill number 434 as sent to the governor, that there's a possibility of $3 million that could be out there for the rural fire departments, for rural fire truck acquisition or supplemental rural fire truck fund.
Oh, there'd be another round?
Correct.
Okay.
And I did verify that with Commissioner Mike Cheney, and he said that's absolutely correct. So if we could get a hold of Mr. Brad Smith, he said if we'd contact him to go ahead and get in front line of that. So what he did say was that basically from the state, they would allocate $70,000 per, and then we would, but that's at least $70,000 from the state that we wouldn't have, that could go
We
towards
could put
something.
that toward that fire truck we just bought.
If that's how, you know, if it fits the
Not sure how it
regulations.
works.
Right.
Yeah, we're not sure how it works.
But we do need to go ahead and get on top of that.
Okay.
Okay. All right. Any other additional business?
Are they about through overlaying old 49?
Go ahead now.
Are they almost through overlaying old 49?
Yeah, they're just about done. They're just doing a few. They got, yeah, they got to do some shoulder work and stuff.
Ask y'all a question.
But
So then,
When we
there's
get
a
done.
possibility they might be moving on up to old Highway 43 here.
Yes,
Hopefully.
very soon.
Time you get out.
hey, who'll be? Are they responsible for the striping and everything on it?
Yes.
Okay, that's what I thought. The whole thing. All right.
We adjourn or recess?
Recess,
Recess.
Till
May the 28th.
We have
Make a
nothing for
motion.
executive session. Okay, to have a motion to recess until May 28th.
so moved.
Second.
Motion by Mr. Bishop, second Mr. Wilcox. All in favor say aye.
Aye.
We barely made it.
Yeah, South wanted to,